Thank you, my lady. Mr. Calata, I hope you are well rested today.
I struggle to sleep in Port Elizabeth, in Gqeberha, but I'm rested, thank you.
Great. Mr. Calata, yesterday you took us through the events that led up to the tragic killing of your father and his comrades. I want to start off today by drawing your attention to page 19 of your statement at paragraph 51, where you deal with the motivation for the murder of the Cradock Four. And I see you quote from the testimony of the late Nyameka Goniwe, her testimony before the Truth Commission. And, my lady, that's in the same dossier that we've previously referred you to. Would you agree with the statements of Mrs. Goniwe? And if so, perhaps you could read them into the record and or perhaps add any thoughts you may have as to why your father and the others were killed.
Which part of the bundle would that be, Mr. Vani?
Just get good at it. We're going to find it for you, but I believe it's item 2 of the bundle, pages... I don't know. My junior is going to find that for us, my lady, and refer it to us.
Okay, can carry on.
You may proceed.
Thank you, Advocate. Thank you, Judge. Yes, I do agree with the testimony as given by Mrs. Nyameka Goniwe, as quoted in the statement. Before the TRC, Mrs. Nyameka Goniwe testified that her husband and others, including my father, were perceived to be a threat to the then regime. She testified that Goniwe was seen as a person who was responsible for the collapse of the community council system in Lingelihle, that he was held responsible for disrupting schools and for the resignation of all the schools committees in the township. She testified, ma'am, that he was accused of mobilizing the people of Cradock and neighboring towns under the banner of the ANC. She testified that he was hated by the security police for raising the level of political awareness of people in rural areas, and that he and his comrades were seen as a communist and a dangerous person who was a threat to the state. I do agree with that. I've also, when I had the opportunity to do research for, as mentioned yesterday, Judge, that I had the opportunity to author and publish a book. As part of that, I had also seen documents where my father was referred to, and the others, they were referred to as terrorists. So yes, I do agree with the statement.
And then if we can move to the nature and form of the murders themselves and the brutal way that they were killed. And I refer you to paragraph 53 of your statement, where you paraphrase the autopsy reports of Dr. Ngqeberha, which is dated 18 July 1985. And perhaps you can just give the court a sense of the causes of death as concluded by Dr. Ngqeberha.
Ma'am, according to the TRC dossier and the autopsy report that was submitted before the TRC, Matthew Goniwe died of multiple stab wounds and consequences thereof. My father, Fort Calata, died of a stab wound in the heart and the consequences thereof. Sparum Konto died of a gunshot wound to the head and stab wound to the heart. Usicelo Mhlawuli died of multiple stab wounds and consequences thereof.
Thank you.
Mr. Van, we referred to a Dr. Noble. I see the statement refers to a Dr. Noble.
Yes, Dr. Noble, that's Knobel.
Okay.
Yeah. He conducted the post-mortems.
I thought you said Noble.
My apologies, my lady, if I did that. Lady, just a quick word on the state of the record. I'm pleased to advise that my learned junior advocate Suleiman, together with my learned friends for the state, advocates Governor and Coltman, worked until the wee hours of last night to prepare a paginated record together with an index, and that they've made substantial progress. My junior advises me that they're 60% there, and that by Monday they hope to present to your ladyship a complete paginated record.
Thank you.
And then, of course, we won't be in the position we are at the moment. My lady, the TRC dossier is actually not in the bundle we handed up, the Lukhanyo Calata bundle, but it is at it's at volume A 3.1 of the latest index that was circulated by the NPA. So, Mr. Calata, those responsible for the killings, could have made this a clean killing, bullets to the back of the head. Why do you think they killed your father and his comrades in such a brutal fashion?
Judge, I think the reason why they had to kill my father and his comrades in the way that they did was basically the whole system of apartheid had made us out as black people to be less than human beings. We were something that we were subhuman, basically. So for these four subhumans to dare to want to be seen as equals of whites in this country was almost like, how dare they believe that they were anything more than the subhumans that the apartheid government had kind of made us out to be. So I think there was a lot of anger. I remember there was a gentleman from Cradock. His name was Gqeberha. But Gilly once mentioned that he was one of the people from Cradock that were sent to come and identify the bodies once they were recovered. And he once said that he could see the hate in the remains of our fathers when he had to identify them. So my estimation was that it was almost to put them back in their place. That blacks weren't anything in this country, and that they had to be killed and humiliated as they were. That's really my thinking.
Thank you. And if we could then turn to the role of the police. From paragraph 57 of your statement, you deal with the role that the police played, in particular that of the security branch. And you point out that Mr. Ganiwe's telephone in Cradock was tapped by the security branch, so that they knew of his movements all the time. Was your home in Cradock ever tapped to the best of your knowledge?
I don't think so. I don't believe so. I think my mother would be able to answer that question, but I don't believe so.
Okay. Milady, the reference for paragraph 58, which deals with the tapping and monitoring of the Ganiwe home telephone, that can be found in the current record. It appears to be at Exhibit C, item 60, sub-item 80, and under that A80. And we rely on the affidavit of a police officer by the name of Fred Zilindile, Zilindile, Koni, Koni, who was a sergeant in the security branch. And the particular paragraph in that affidavit is paragraph 24. And he was in the transcription department. So once they had put together the transcripts of the conversations they were monitoring, he would then hand it over to an officer by the name of Van Rooyen, who in turn would then decide what would be sent to the head of the security branch in Port Elizabeth, who was Eric Winter. Mr. Calata, if we can just move on in your statement to paragraph 59. Perhaps you can just read into the record that paragraph dealing with the plan to conduct this operation.
Paragraph 59 reads as follows, Judge. A plan was devised to abduct and murder them. Major Johan Martin Saki van Zyl was placed in charge of the operation. His instructions were to make the murders appear to be the result of a vigilante attack, which was a common cover-up tactic of the security branch at the time.
Milady, we would like to refer this Honourable Court to the TRC transcript, the amnesty transcript of the hearing dealing with Mr. Saki van Zyl, which took place on the 23rd of February 1988. That's at in the current index, milady. That's at item 62, part 1, pages 3 to 4.
When you refer to the current record, what are you referring to, Mr. Vane?
The current index that was circulated, I believe, the week before this inquest started.
Okay. Yes, carry on.
Mr. Calata, let's now deal with the instructions, where those came from. And can I ask you to take a look at your paragraph 61? And please, could you read that into the record?
All right. Paragraph 61 reads as following, Judge. According to Janse van Rensburg, he received instructions in this regard from his immediate superior, the late Harold Snyman, who was the head of the Port Elizabeth security branch. Snyman, in turn, claimed that he was told by the former Minister of Law and Order, the late Mr. Louis Lukhanyo, to deal with those in leadership positions who were directly responsible for the unrest in the Eastern Cape.
And milady, for that paragraph, we refer you to item 14 of the Lukhanyo Calata bundle, to the amnesty decision of Judge Zietsman, and that's at pages 29 to 36 of that bundle. Mr. Calata, we've already dealt with the facts around the actual murder. Let's now turn to the events that took place post the murders. And you'll notice from your paragraphs 64 and 65 that attempts were made to distribute the remains of your father and the others, and also to destroy as much evidence as possible. Can I ask you to read into the record paragraphs 64 and 65 of your statement?
Yes. Judge, the following paragraphs reads, Goniwe's vehicle was taken to a place on the road to Edo, where it was set on fire and almost completely destroyed. This was done to prevent the car being identified as belonging to Goniwe. Both number plates were removed. A severely burnt false number plate with the number CB 10627 was left lying in front of the vehicle. One of the original plates, not damaged or burnt, was left in the grass behind the vehicle. The mutilated bodies were found spread out over a wide area in the Red House and Blue Water Bay areas on the outskirts of Port Elizabeth. The bodies, and especially the faces, were doused with petrol and set on fire with the intention of rendering them unrecognizable and therefore not identifiable. It was apparent that the special branch went to great lengths to prevent identification and to eliminate clues which could link the bodies to each other and to the burnt out vehicle.
So, Mr. Calata, do you need a moment just to
I'm good.
Okay. So, in your view, why do you think that they simply didn't leave the bodies where they had killed them, or why they simply didn't do it all together? What do you think was the motivation behind that?
Judge, I think that, as we had indicated yesterday, that there was the signal that was sent out. And as part of that signal, there was a word of caution in the military signal that they could expect widespread. I'm just trying to find the word, but they could expect widespread reaction to these murders. So, to try to disconnect these murders and the bodies from the car, I think that they spread them out as far as they could, but also so that they could not be linked back to the car that we knew that, or that they knew belonged to Umefi Goniwe. I just think it was just a ploy Judge, to try to hide the crime and to deceive those that would be investigating, from failing to make the necessary connections in this whole matter.
And Mr. Calata, what was the public explanation that the police and the authorities made for these murders?
At the time, Judge, the explanation that was made was that the Cradock Four could have perhaps been killed by a Zapo, and that it was black on black violence, infighting, I suppose, between the different liberation movements, between the African National Congress and a Zapo and all of those.
Mr. Calata, you make that point of this fabricated story at paragraph 66 of your statement. Milady, at page 29 of the Lukhanyo Calata bundle, there is a finding from the Truth Commission to this effect. And we also refer your ladyship to page 72 of the same bundle, which includes Saki van Zel's amnesty application. And we refer the court to paragraph 9, where Saki van Zel says that this was the plan, that they would be blaming it on a Zapo. Mr. Calata, let's now turn to the attempts to get to the bottom of the murders, starting with the first inquest, which you deal with at paragraph 68 on page 24 of your statement. Perhaps you can just read into the record the ultimate finding of Magistrate E. Gqeberha, which was handed down in February 1989.
I'll read the entire paragraph.
You may.
Judge, paragraph 68 reads as follows. In February 1989, an inquest into their deaths was held at New Brighton, Port Elizabeth by Regional Magistrate E. Gqeberha. Inquest number 626/87. The families were represented by Advocate Arthur Chaskelson, SC. Despite evidence pointing to state involvement, the magistrate found that the Cradock Four's deaths were brought about by a person or persons or a group of persons unknown.
Mr. Calata, you would have been too young at the time to have your own reaction, but looking back at that finding, how did the families respond to that particular finding?
It's interesting because we were talking about it in the bus when we were doing the in-loco inspections just this week. It was preposterous, Judge, that my father and his comrades were killed in the heinous and brutal way in which they were killed. But for Magistrate Gqeberha to find that they were killed by persons or a group of persons that were unknown. There was something very interesting, Judge, and I hope I can say this, but that Mrs. Mkhawuli mentioned in the bus, and we'd actually, we'd never heard it before. But she mentioned that that entire first inquest was conducted in Afrikaans, and she doesn't speak Afrikaans. My mother was, my mother speaks Afrikaans, so all four of the widows at the first inquest basically were saying to her the whole time, Nomonde, what are they saying now? And then my mother would have to translate. Sometimes my mother wouldn't hear what was being said, and then she would just tell them that, she couldn't hear. But there was a small little anecdote, obviously because, it was a very serious discussion that we were having in the bus. But Ms. Mhlawuli had a small anecdote, and she says that the only thing that she remembers was this young lawyer, I forgot his name, I think his name, she mentioned Kobus. And all she remembers was Kobus just going, Akhbar, because he was trying to get some form of, I suppose, postponement or leniency or something to get the judge to try to understand that, this was all happening so fast, they didn't understand what was going on. And really, it was really funny in the bus when she kept on saying that her only memory was, akhbar.
Mr. Calata, let's turn to the second inquest. Can you explain to the court how it was that a second inquest came to be held? The second inquest came to be held after the New Nation newspaper published an article on the 30th of April 1992 that revealed a top secret military signal that had called for the permanent removal from society of Gqeberha, Calata and Umbulelo Gqeberha. Now, as a result, the Minister of Justice instructed the Judge President of the Eastern Cape Local Division, Neville Zitzman, to reopen and preside over that inquest. If I may, Judge, when I was working at the SABC, I worked for the SABC as a parliamentary reporter in Parliament. And I used to sit next to my colleague, Umanelisi Dubas. And he told me the story once that he was working for the New Nation newspaper at the time, and how they were sent by their editor. 2 reporters were sent by the editor. They had received a phone call from General Bantu Olomisa, and he had informed them that he had this dossier which included this signal. So the editor sent them down to Mthatha, and one of the reporters was actually given the dossier, but then they drove different routes to get back to Johannesburg. He says that his colleague who had the dossier drove, I think, through Mthatha to Durban and then on to Johannesburg, and then he drove through Cradock because they didn't know if they were being followed, and to obviously, if something happened to either one, maybe if the security branch or if the police were to attack one of them, they didn't know which one had the actual information, and that's how the New Nation got this actual dossier from General Bantu Olomisa. Thanks for that anecdote. Malady, I understand that my learned friends for Mr. Mbele Gqeberha and the community will be calling General Olomisa to testify in this inquest at some future date. So let's return to the second inquest, Mr. Calata. And can I ask you to read into the record certain conclusions reached by Judge President Zitzman? And let's start with his findings at paragraph 72 and 73, please.
Right. Paragraph 72 and 73 reads as follows, Judge. Judge President Zitzman concluded in his judgment 1994 SA 877 SECLD that the deaths of the Cradock Four were brought about by deliberate acts committed by an unknown person or persons, which acts constitute murder on the part of such person or persons. But the judge was unable to conclude that it had been established prima facie that the murderers were members of the security forces.
Just a small question, a small correction, but the judge was able to conclude.
Oh yes, sorry, Judge. 73. But the judge was able to conclude that it had been established prima facie that the murderers were members of the security forces. Apologies on my part on that, Judge.
No problem. And then if we can ask you to also read into the record certain other findings that Judge Zitzman made in his judgment. And I draw your attention to paragraphs 76 and 77, and please read those into the record.
All right. Paragraph 76 reads as follows, Judge. Judge Zitzman noted in his judgment that Colonel Lawrence du Plessis, who authored the signal, understood the instruction in the signal to mean kill. At pages 42, 72 to 73, the judge found at pages 74 to 75 that, in my opinion, it has been established prima facie that the signal was intended by Colonel du Plessis to mean that Matthew Goniwe and the others should be killed, and also that this is the meaning that Brigadier van der Westhuizen intended should be conveyed in the signal. Judge Zitzman concluded, it has, in my opinion, been established prima facie that the murderers of Matthew Goniwe, Sparom Konto, Fort Talat, and Sicelo Mhlauli were members of the security forces. A case of suspicion has been made out against certain members of the police force, including Colonel Snyman and Colonel Winter, and against certain members of the South African Defence Force, including Brigadier van der Westhuizen, Colonel du Plessis, and Major General van Rensburg.
Thank you, Mr. Calata. Now, at that time, to the best of our knowledge, all the named individuals, at least those against whom the learned judge found there was a case of suspicion, were alive. What did you and your families expect to happen after those findings were made in that inquest?
Judge Neville Zitzman delivered his judgment, I think, on the 28th of May, 1994. It was shortly after former President Nelson Mandela had been sworn into office on the 10th of May as the first democratically elected President of the Republic of South Africa. So we had expected, Judge, that with the findings of the second inquest, that there would be prosecutions, that people would be held accountable for murdering our fathers and obviously our mothers' husbands. There was a lot of hope, Judge, that in democratic South Africa we would finally receive justice, because now there was a court then that had said that these are some names who were suspected of having been involved, and that, you know, they needed to be prosecuted, or there was at least a suspicion. And we thought that justice would then follow in the form of prosecutions, Judge.
So, just so that you're aware, Mr. Calata, a case of suspicion isn't high enough for, it doesn't meet the threshold for a prosecution, but it's certainly a basis for investigations. Yes. So the families were expecting some vigorous action and investigations, as I hear you saying.
Yes, of course. So we can't all be lawyers, I feel. So, in our estimation, if there's a suspicion, then obviously the state must do what it has to do, but that ultimately, you know, that the steps would then follow, which would ultimately then lead to charges being laid, prosecutions, and then convictions. Right. Yeah.
Mr. Calata, if you ever tire of journalism, there is a career waiting for you in law.
I agree.
I appreciate that, ma'am.
Let's now move to what happened before the Truth and Reconciliation Commission. And the Truth Commission itself, through its own investigations, made certain findings. We know that, you point this out in your statement at paragraphs 80 and 81, that the wives, your mother and the other wives, testified before the TRC, and we're going to be hearing from some of them. The Commission made an important finding, Mr. Calata, and you reflect that at paragraph 82 of your statement. Could you read that into the record, please?
Judge, paragraph 82 reads as follows. The TRC noted that an attempt was made by the state to suggest that the deaths of the four were the result of ongoing and violent conflict between AZAPO and the UDF in the Eastern Cape. The Commission found evidence that this fabrication was formulated by the Strategic Communications Branch, or Stratcom, of the State Security Council's Secretariat. The Commission found that the attempt to lay the crime at the door of AZAPO in the Eastern Cape was not only a case of disinformation, but a deliberate attempt to stoke conflict that had already claimed lives in the Eastern Cape.
My lady, we give the reference for that finding in the statement. It's at volume 2, chapter 3 of the final report of the TRC, paragraph 251. Now, Mr. Calata, you've already indicated to this court that several of those involved in the murders applied for amnesty. And at paragraph 84, you mentioned those names, and since they are already on record, I won't ask you to repeat them. Milady, for your convenience, that TRC finding is actually at page 29 of the Lukhanyo Calata bundle. But I will ask you to read into the record certain findings made by the Amnesty Committee. And can you read into the record paragraphs 85 and 86 of your statement?
Yes, certainly. Judge, paragraphs 85 and 86 read as follows. The TRC Amnesty Committee, in its ruling, Amnesty Committee Decision AC/99/0350 of 14 December 1999, found that the foot soldiers who actually perpetrated these deeds acted on the instructions of Nicholas Janse van Rensburg and Hermanus du Plessis, who supported and approved the killings. Paragraph 86. Van Rensburg in turn received instructions from Harold Snyman. In tracing the chain of command, the committee found that the order from Snyman that the best must be done for the country meant that he approved of these assassinations. Minister Lukhanyo told Snyman in a conversation that a plan needed to be made regarding the unrest in the Eastern Cape. Snyman interpreted this as an order to assassinate those leaders directly responsible for the unrest.
Thank you, Mr. Calata. Milady, we give the references in the amnesty decision in those paragraphs. So for paragraph 85, it's page 2, lines 18 to 19. And for paragraph 86, it's also page 2, lines 20 to 27. And we also have that decision. My learned friend tells me that it's at page 32 of the Lukhanyo Calata bundle. Mr. Calata, you set out in some detail facts that emerges from the amnesty application of Saki van Zyl, the nature of the orders he received from Snyman and van Rensburg. Milady, just to keep the court informed, or was just to remind the court, Snyman was the then head of security branch in PE, in fact for the region. Nicolas Janse van Rensburg was his second in command, and Hermanus du Plessis was head of black affairs for the security branch. Mr. Calata, can I refer you to paragraph 88 of your statement, where you refer to an exchange between Minister Lukhanyo, the Law and Order Minister at the time, and Mr. Snyman. And since that is an important exchange, can I ask you to read that paragraph into the record?
Judge, paragraph 88 reads as follows. In Snyman's application for amnesty, he referred to a safety and education meeting held on approximately 14 February 1985, at which Minister Lukhanyo approached him during an adjournment and told him that he was expected to make a plan with the agitators in the Eastern Cape. He understood this to mean that Gqeberha and others had to be killed. This was especially so since, according to Snyman's affidavit, it was discussed and recorded at this meeting that the normal legal options were no longer a solution for the problems faced in the Eastern Cape.
Milady, Snyman's application for amnesty are reflected at items 18 and 19 of the Lukhanyo Calata bundle, pages 79 through to 91. And Mr. Calata, the TRC Amnesty Committee made a finding in respect of the plan to murder the Cradock Four, and you reflect that at paragraph 89 of your statement. Can I ask you to read that finding into the record?
Paragraph 89 reads as follows, Judge. The plan devised by the applicants to murder Gqeberha was then put into operation. Johan Martin van Zyl, also known as Saki, was charged with handling the operation, which included the execution of Gqeberha. The murders of the Cradock Four would be made to look like the result of a vigilante attack. Indeed, it seems that the manner in which the murders were committed confirms that part of the plan. In order to execute the murder, he elicited the assistance of Eric Alexander Taylor, Gerhardus Johannes Lotz, as well as the late Sergeant Faku, Goduga, and Sakati.
Now, Mr. Calata, we're aware, and as you point out at paragraph 90, that all the applicants for amnesty, with the exception of Eugene de Kock and Jaap van Jaarsveld, were refused amnesty. What was your reaction and that of the families to the refusal of amnesty?
Again, Judge, our understanding was that when someone was refused amnesty, prosecutions would follow. If I may add, Judge, on either the 4th or the 5th of June 1995, former President Nelson Mandela came to Cradock to come and lay a wreath at the graves of the Cradock Four. And he obviously spoke there about how our fathers were the real heroes of the struggle against apartheid, or the struggle for freedom. It was shortly after, I think, about 2 months after he was in Cradock, that he then signed the Promotion of National Unity and Reconciliation Act into law. And that was the act that then paved the way for the TRC. And we, at the time, my mother and them, they met with lawyers, and we were made to believe that part of that was that if someone has been denied amnesty, they can then be prosecuted if they're denied amnesty.
So that was the expectation of the family?
Yes, that was definitely the expectation, Judge. Definitely.
And Mr. Calata, my team will be providing the dates of death of all those refused amnesty. But to the best of my knowledge, at the time they were refused amnesty in 1999, with the exception, I believe, of Harold Snyman, they were all alive and potentially could have faced justice. And yet here we are, many years later, and we know that they didn't face justice. So how did that impact you and your families?
First of all, are you in a position to confirm that indeed was the case, that they were still alive at the time, except for maybe one?
Ma'am, Gerardus Lots, yes, I can confirm that he was alive. When he died by committing suicide, I was already I'd been working as a journalist for a while, and I think I was either at the SABC or potentially by then at ETV News and Sport. It was one of those, ma'am. But I remember having reported on the death by suicide of Gerardus Lots, and that was much, much later than 1999. So I can definitely confirm that. Eric Taylor. Eric Taylor died in November 2016. This was confirmed to us by Dominee Charles Coetzee, who is one of the witnesses that will be called. So I can at least confirm those two. And then was it Baron du Plessis, who died, I believe, in 2023, in May 2023. So those three, by then I was working as a journalist, so I can confirm at least those three off the top of my head, Judge. Sorry, what was the question?
Milady, I believe the death certificates are in the record, and once we do have the final paginated bundle, indeed my junior has told me that the death certificates are in volume A of the current bundle. A72 is the death certificate of Janssen van Rensburg, A73 that of Lotz, A74 of Taylor, A75 of Sneeman, A76 of Hermanus Barent Duplessis. And during the course of the day, we will extract them and bring them to your attention together with the dates of death. So we're aware that most of those refused amnesty were alive for several years after they had been denied amnesty.
Yes.
And the fact that no action was taken against them, they were allowed to die peacefully, in a sense.
Yeah.
What was the impact of that on your family?
Ma'am, so these guys had we get to interact with Afrikaans people, English people, white people on a daily basis. From there we are able to understand that family means a lot to Afrikaners, to English people, and that their whole lives center around family and the importance of family. So what I could never understand is that if this community places so much value and emphasis on family, why was it so easy for them to just tear our families apart? Because Fort was my father, Judge. And it didn't matter that he had a black skin. Because a father in a black family holds the exact same significance as a father in a white family. A husband in a white family holds the exact same significance in a black family. So, why did our families not matter? Why could it be that they could desecrate my father's body in the manner in which they desecrated him? And for that not to mean anything. So,
for no action to be taken, is that what you mean?
Yes, ma'am. So we struggled, and we continue to struggle to understand why there was never anybody held accountable for ripping our families apart. And that's a daily struggle, ma'am. And I'm trying to stand here and be strong. But when I talk about it, ma'am, it really makes me really emotional because of the struggle and the pain that we have had to endure for nearly 40 years now, ma'am. Advocate, I don't know how to explain it. But
Mr. Calata, your anguish and your loss of words is totally understandable.
Thank you.
Let's move on, Mr. Calata. You make reference in your statement to the Motherwell bombing connection. What is the connection between the Motherwell bombing, if you can explain what happened in that case, to the case of the Cradock Four, or the possible connection at least?
Yeah. Ma'am, what we know about the Motherwell bombing was that it was it was a car that exploded whilst transporting 3 police officers, and these officers were Sergeants Faku, Goduga and Sagat. And these were the same sergeants that were implicated in the murders of the Cradock Four.
And I see in your statement that that particular bombing took place on 14 December 1989 at or near Motherwell, which is a district of Port Elizabeth. And certain individuals applied for amnesty. Perhaps you can just read into the record paragraphs 93, 94 and 95, which seems to establish the connection with the case, with the Cradock Four case.
Paragraphs 93 to 95 read as follows, Judge. Some of the amnesty applicants were associated with the murders of the Cradock Four, including Gerardus Jacobus Lotz, Nicholas Janse van Rensburg, and Eugene de Kock. All were refused amnesty. The Amnesty Committee found that the reason for killing the deceased was to prevent them from disclosing allegations of fraud within the special branch and to conceal the illegal activities of the security police. Major General Nicholas Jacobus Janse van Rensburg testified in his amnesty hearing that Gideon Nieuwoud, who was also refused amnesty for his role in the Motherwell bombing, was concerned that the 3 policemen could divulge details of their involvement in the murders of the Cradock Four.
The lady at items 20 and 21 of the Calata bundle, pages 92 to 95, the extracts from the amnesty decision in the Motherwell case is included. Mr. Calata, in your statement, you appear to reach the conclusion that this was not just an incident that happened at the local level, but that the State Security Council system was implicated. And from page 31, you set out in some detail why you reached this conclusion. And you give some background to the State Security Council and its structures. I'm going to ask you to read into the record a few of those paragraphs, starting with paragraph 100 and 101.
Paragraph 100 reads as follows, Judge. The State Security Council was a special cabinet committee on security set up in 1972. In terms of the Security Intelligence and State Security Council Act, Act 62 of 1972, the SSC was composed of the State President as chairperson, senior cabinet members and members of Foreign Affairs, Defense, Law and Order, and Justice, the Chief of the South African Defence Force, and Commissioner of Police, as well as the Director Generals of National Intelligence, Foreign Affairs, and Justice. In addition, the State Security Council was empowered to co-opt ministers and officials of other departments on a permanent or ad hoc basis. In terms of Act 62 of 1972, the SSC was to play an advisory role to Cabinet regarding the formulation and implementation of national security policy, policy regarding the combating of any specific threat, and intelligence priorities.
You can also read paragraph 101.
Paragraph 101 reads, however, the State Security Council assumed decision-making powers far beyond the advisory powers conferred upon it in the Act. It was in the SSC and not Cabinet where matters of greatest sensitivity and importance were deliberated and agreed upon, with Cabinet merely providing a rubber stamping role.
Milady, much of the section of Mr. Calata's affidavit is reliant on the Truth Commission report, and we will provide you with the references. And also another report prepared during 1997 by the civilian support component of the Investigation Task Unit, titled The Apparatus of State-Orchestrated Violence in Apartheid South Africa. Milady, that report is reflected at item 22 of the Calata bundle on pages 96 to 218. Mr. Calata, you make reference to the Deputy Minister of Law and Order, who at that time was Adrian Vlok. And you explain his designation and role, paragraph 103. Can you just read that into the record?
Yeah, surely. Paragraph 103 reads as follows, Judge. The State Security Council was assisted by a working group which was chaired by the Deputy Minister of Law and Order, and which included the Secretary of the SSC, as well as the heads of departments represented on the State Security Council.
And you point out that the State Security Council was not just one council, but it sat at the head of a body known as the National Security Management System. Can you read into the record your paragraph 105?
Paragraph 105 reads as follows, Judge. In August 1979, the establishment of a National Security Management System was officially announced. The NSMS was a vast bureaucracy intended to coordinate all the arms and departments of the government in a united and total effort to counter the perceived total war against South Africa. It was through the NSMS where the doctrine of the total strategy was embraced and expounded, and where actions, both legal and illegal, were authorized.
Now, we don't have time to go through all the different entities connected with this state security system, but I do want you to focus on two entities that you refer to in your statement, namely that of Stratcom and a group known as Trevitz. So let's start by asking you to read into the record paragraph 107.3 and paragraph 108.
All right. 103 all the way to 104?
Take it through to the end of those subparagraphs.
All right. Paragraph 107.3, Judge, reads Strategic Communication, or Stratcom. Stratcom developed strategies to combat the total onslaught. One of its aims was to discredit anti-apartheid organizations, neutralize anti-government publicity, and promote a positive image of anti-communist groups by using the Bureau of Information to overtly sell the government message. And secondly, it employed covert propaganda through other entities. Stratcom also had a more sinister component, Judge, which included the use of murder, intimidation, economic sabotage, character assassinations, and front companies against anti-apartheid personalities and organizations. Stratcom was directly accountable to the State Security Council, while projects which focused on a specific sector of society had to be approved by the relevant minister.
And actually, we can now skip to paragraph 108.
Right. The other State Security Council committees, this is paragraph 108, Judge. The other State Security Council committees included the Coordinating Intelligence Committee, known as KIK, from its Afrikaans name, Coördineer Inligting Komitee, and Counter-Revolutionary Intelligence Task Team, known as Trewits, from its Afrikaans name, Teen Revolutionaire Inligting Taakspan.
And please read the subparagraphs as well.
KIK, also known as the K Committee, was established in early 1981 and was chaired by the recently deceased Neil Barnard. Its function was to coordinate activities and intelligence between all intelligence agencies and the non-security agencies. It had several subcommittees including covert collection, later called Trewits, open information gathering, technical evaluation, later became NIIB, and counter-espionage and security intelligence. Now, Trewits, also known as Section J, was formed in 1985 to identify targets for action and elimination. It gathered intelligence for these operations. Trewits was under the command of the security branch, but included members from the NIS, DMI, and Special Forces. Trewits interacted with the Joint Management Centers through the VACOM security committees.
Thanks.
Sorry, it's VACOM. I would imagine it's short for Veiligheidscommittee, Judge, in Afrikaans.
That's correct. And my letter, of course, NIS stands for National Intelligence Service, and DMI stands for Department of Military Intelligence. Now, if we continue, Mr. Calata, and turning to the joint management centers, which operated under this system, you make reference in paragraph 110 to the fact that it was divided between two arms, the security management system and the welfare management system. Let's focus on the first one, the security management system. And in paragraph 112, you describe how these joint management centers or JMCs worked. Please could you read into the record that paragraph?
Paragraph 112 reads as follows, Judge. Through a hierarchy of 500 regional, district, and local joint management centers, JMCs, these State Security Council directives were translated into practical actions on the ground. Representatives of the South African Police, the Security Branch, the South African Defence Force, provincial and local government sat on these bodies, but they were dominated by the security sector.
And in the very next paragraph, you describe the actual structure of the JMCs. Please could you read that paragraph, sub-paragraphs into the record?
Paragraph 113. The JMCs were the hands and feet, as well as the eyes and ears of the State Security Council on the ground. They oversaw and coordinated the daily implementation of strategies flowing out of the State Security Council. The Joint Management Centers also continuously fed intelligence and situation reports back up to the SSC. The JMCs were structured as follows. The National Coordinating Committee, 11 JMCs regional, which replicated the South African Defence Force command regions, 60 sub-JMCs, these were the districts, 350 mini-JMCs, these sat at municipal level, and then numerous local government management centers at police station and commando level.
Yes, that actually reads local management centres.
Yeah, local man.
And then if we carry on, Mr. Calata, the work of these JMCs, and I draw your attention to paragraphs 116 and 117. Could you read those two paragraphs into the report?
Yeah. Paragraph 116 and 17 reads as follows, Judge. The primary role of the JMCs was to collect intelligence on persons and groups who acted against the interests of the state. Information would be sent up the chain of command from the lowest level to the JMC, then the SSC and its working committees, and finally the Prime Minister or State President. The JMCs reported on the activities and location of political activists to form an overall security profile to facilitate decisions on security actions to be taken. Such actions included the harassment, torture, abduction, and elimination of persons opposed to the government. A secondary and neglected role was the hearts and minds strategy involving socio-economic and political steps.
Thank you, Mr. Calata. Now let's turn to some of the findings that the Truth and Reconciliation Commission made against the State Security Council. And perhaps the most important one is reflected at paragraph 118 of your statement. Could you read that finding into the record, please?
Paragraph 118 reads as follows, Judge. The TRC concluded in its final report that the State Security Council played a central role in the to an extra-legal response to the growing threat to the apartheid state. However, in the 1980s, when the state was in crisis, it became clear that the law had run its course, that it could no longer do the job. The law had become ineffective, an apparent obstruction to the restoration of what government leaders, seemingly oblivious to the irony, called law and order. At this stage, real rule-making power shifted from Parliament and the Cabinet to a non-elected administrative body, the State Security Council, which operated beyond public scrutiny. Nominally, a sub-organ of the Cabinet, in reality, the SSC eclipsed it as the key locus of power and authority in matters relating to security.
And Mr. Calata, there is a reference by the Truth Commission to a statement made by the former head of Security Branch Intelligence, Craig Williamson, and he attempted to explain to the TRC what explained this shift. Could you enter into the record that quote as reflected in the TRC report?
The quote under paragraph 119, Judge, reads as follows. A democratic state is often limited by its laws, values, and norms in the methods it can use to defeat an insurgent movement. Its solution is to resort to extra-legal counter-revolutionary acts as long as they are done secretly.
Milady, perhaps at the next session of this inquest, we hope to hear from Craig Williamson, who's one of the witnesses who has been subpoenaed to appear. Mr. Calata, you also make reference in your statement to different kinds of words that have been used in state security documentation. Perhaps the one you're most familiar with is in the infamous signal that was sent on the 7th of June. But there have been other ones as well. If I can refer you to the bottom of page 39 in paragraph 120, where you point out that the state security documents never directly use the word murder, but other words. Could you read into the record some of these other words?
Yeah. Judge, the other words that were used were eliminatie, verwyder, neutraliseer, and uitwis, loosely translated as eliminate, remove, neutralize, and wipe out.
Now, the Truth Commission made a finding, a lady that's reflected in paragraph 121 at paragraph 96, volume 5, chapter 6 of the Commission's final report. Mr. Calata, they made the following finding as you reflect that those in charge of the security apparatus reasonably foresaw that such words could be interpreted by members of the forces as an authorization to kill. And you set out in paragraphs 121.1 to 3 the basis for the Commission's finding. Please could you read those paragraphs into the record?
Paragraphs 121.1 to 3 read as follows, Judge. If the directives of the State Security Council and its structures were all lawful, as alleged by members like Mr. F.W. de Klerk, General Magnus Malan, and Dr. Neil Barnard, these would have been explicitly spelt out. If the intention was to detain, restrict, arrest, ban, or deport, these are the words that would have been used. Since the military and the police operated on a basis of clear and precise instructions, the words must have been intended to convey their normal meaning. There is no evidence of any attempt by the State Security Council to set in motion any independent, substantive, or comprehensive investigation into the killing of political opponents once this began to happen. Given that it was common knowledge that police investigations of such crimes generally took the form of cover-ups, neither did the SSC at any stage issue any statement or directive clarifying its orders and strategies to the effect that they should under no circumstances be interpreted as authorization for illegal activities.
Thank you, Mr. Calata. Milady, I see it's 11 a.m. Would this be an appropriate time for the tea adjournment?
Yes, let us take a break of 15 minutes. Court will adjourn for tea until 11:15. All right.
we were dealing with the State Security Council and the potential role that that council and its structures played in the murders of the Cradock Four. You set out in your statement a number of examples of the kinds of measures that the council took. We won't have time to go through all of them, but they are on the record in your statement. But if I can ask you to read into the record a statement made by the former Commissioner of Police, Johan Velder van der Merwe, to the Truth and Reconciliation Commission in his submission. That's at paragraph 122 on page 41.
Judge, the paragraph 122 reads as follows. Mr. Johan Velder van der Merwe, the former Commissioner of Police, said at the TRC's hearings on the State Security Council that we had to move outside the boundaries of our law, leading to all sorts of blurred distinctions between acceptable and unacceptable methods. This point was also conceded to by Mr. F.W. de Klerk in the National Party's submission.
I want you to also read into the record a quote that's recorded in the Truth Commission report by one Brigadier Jan Hatting Jack Cronje, who was the former divisional commander of the Northern Transvaal Security Branch. That's at page, at least, yeah, it's at bottom of page 41, paragraph 126 of your statement.
Paragraph 126 reads as follows, Judge. The TRC recorded that the late Brigadier Jan Hatting, or Jack Cronje, the former divisional commander of the Northern Transvaal Special Branch, was more explicit about the chain of command. In respect of an instruction to murder, he had been given this order. Quote, by General van der Merwe, and during this instruction, he specifically indicated to me that this came directly from Minister Lukhanyo, and that it had indeed been authorized by President P.W. Botha, as well as Commissioner Johan Coetzee, both of whom knew about this and authorized it. If it should be claimed, therefore, by anyone that the State Security Council was not aware of the actions of the security forces and the security police, or of any specific incidents, this would not be true.
And my lady, we give the reference in the Truth Commission report to that quote. And if we can return to Craig Williamson, who also applied for amnesty in matters unrelated to the Cradock Four. He made a comment in relation to the chain of command and how information was treated and where it went, and that's at paragraph 128. If you can read that into the record, please.
Yes. Paragraph 128 reads as follows, Judge. Excuse me. Amnesty applicant Craig Williamson, who had been a political appointee on the President's Council in the late 1980s, commented, once it got up to the Gqeberha, or National Joint Management Center, it became the political control level where a deputy minister then received the information from the civil service below. And when I say civil service, I include the security forces. And this information was then fed up via the work committee and the State Security Council. And on a political level, I believed directly either to cabinet or to the state president. Once the information had arrived at the Gqeberha and then to the State Security Council, the information was in political hands.
Lady, that was at his amnesty hearing in Pretoria on the 14th of September 1998, and we give the reference at the bottom of that quote. So, Mr. Calata, in the light of that background, what conclusions do you reach as to the role of the State Security Council in relation to the murders of the Cradock Four?
The only conclusion that I can make, ma'am, was that the State Security Council had a direct role in the murders of my father and his comrades. Direct in the sense that they would have been made aware of it, and that an instruction would have been given at that level that would then have filtered back down for my father and his comrades to be murdered.
And you say, and I refer you to paragraphs 129 and 130, that you're not aware of any State Security Council member or official who did certain things or took certain steps. Can you read into the record those omissions? That's 129.1 to 3.
129 reads as follows, Judge. In the light of this background, I believe that it can be reasonably assumed that those serving on the State Security Council and or its structures were either party to the issuing of instructions, such as the elimination of the Cradock Four and its cover-up, or were kept informed of such plans and what transpired in the aftermath. We are not aware of any member of the State Security Council or official who, 1, objected to the systematic killing of anti-apartheid activists, or 2, sought an independent inquiry into the ongoing murders, or 3, issued any clarifications regarding its directives and specifically ordered the halting of such illegal operations.
And also paragraph 130?
130. In the circumstances, even if members of the State Security Council and officials were not directly involved in such operations, they must still be held to account for their roles in tacitly approving the operations and deliberately choosing not to take steps to stop them and punish the perpetrators.
So, Mr. Calata, let's now turn to how the state security system dealt with the Cradock Four. And in your earlier evidence, you've already pointed to the 19th March 1984 SSC meeting at which the then Minister of Black Education called for the removal of the 2 teachers who were agitators. And you've already referred to subsequent developments. We won't repeat those. The detentions, the fact that a signal was sent proposing that your father and Mr. Gqeberha never be reappointed, and then ultimately culminating in the 6th June 1985 subcommittee known as the Action Committee, which Mr. Flock called for recommendations. So that then brings us up to the very next day when the infamous signal of the 7th of June was sent. And can I ask you to read in the record paragraph 139, including the complete translation of the signal?
Judge, paragraph 139 reads, While the Geldenhuys Committee deliberated on whether to reappoint Gqeberha or not, it was apparent that a parallel process was underway. A day later, on 7 June 1985, the infamous signal was sent under authority of Brigadier van der Westhuizen to Major General van Rensburg, proposing the urgent, permanent removal of Gqeberha from society. In our view, it was this signal that precipitated the demise of the Cradock Four. Judge, I quote the complete translation of the signal below. Personal for General van Rensburg. 1. Telephone conversation, General van Rensburg and Brigadier van der Westhuizen of 7 June 1985 refers. 2. Names as follow: Matthew Gqeberha, Mbulelo Gqeberha, brother or nephew of above, and Fort Calata. 3. It is proposed that the above mentioned persons, as a matter of urgency, be permanently removed from society. Wide reaction can be expected locally as well as nationally as a result of the importance of these persons, especially the first mentioned, for the enemy. E.g., interdicts as recently with disappearance of Godolozi, Ashe, and Galela, PAPCO officials, reaction from leftist politicians such as Molly Blackburn, and protests as in the case of Oscar Mpeta in sympathy.
So, Mr. Calata, there has been a suggestion that was made by some of the witnesses in the Zietsman inquest that there's nothing sinister about permanent removal from society because it could be simply construed as a transfer or a reinstatement to a new post, perhaps in a different town. What's your response to that?
I think in some instances people try to defend the indefensible. In Afrikaans, the signal talks about permanent verwyder. Now we can debate what the word of permanent means. Permanent means permanent, you do it forever. Verwyder, judge, means you remove. So if you permanent remove something, you remove it forever. And I'm not quite sure why we would have to debate something that's as obvious as permanent verwyder or permanently remove, because it's as clear as night and day. Again, it says permanent verwyder van die samelewing in Afrikaans. Samelewing, ma'am, I'm ndingumxhosa ndiphuma ngapha eKradock. I come from a family where it's interracial, and we learned to speak Afrikaans. I probably spoke Afrikaans before I learned to speak isiXhosa. So I understand Afrikaans pretty well. And by understanding Afrikaans, I think I understand Afrikaners a little bit and their culture. So for me, I don't consider, yes, this is a translation, judge, but permanent verwyder van die samelewing. Van die samelewing is not permanent verwyder van Cradock of permanent verwyder van Lingeliche, is van die samelewing. And that means remove him permanently from society. I'm generally, judge, I am a little bit impatient. And conversations like these, I don't think I would ever entertain, because here it says permanent verwyder van die samelewing, remove permanently from society, finish and klaar. That was the intended message. That is what happened afterwards. And anyone who says differently, I'm not sure I can say in court what I really want to say.
Please don't.
No, I won't.
Mr. Calata, thank you for your restraint.
Thank you.
Now, there's a rather striking reference in that signal, amongst the wide reaction that they could expect would possibly be certain legal action taken, and they refer to interdicts as recently with disappearances of Budolosi, Hashe, and Galela, in brackets the PEPCO officials. And in paragraphs 140.2 as well as 140.3, you make reference to the significance of the fact that they chose to highlight what happened to the PEPCO 3, or rather the legal action that transpired after their disappearance. Can you read into the record paragraphs 140.2 to 3?
Paragraphs 140.2 and 3 read as follows, Judge. The reference to the disappearance of Godolozi, Hashe, and Galela, the PEPCO 3, is most telling, as they were also murdered by the security branch and their bodies burned just weeks earlier, between 8 to 10 May in 1985. The legal action mentioned in paragraph 4A referred to the high-profile habeas corpus applications brought on 19 May 1985 before the Eastern Cape Local Division of the Supreme Court under case number 1803/85 by the families of the PEPCO 3 against the South African police to produce their bodies.
So, Mr. Calata, does that suggest to you in a loud and clear manner what might have happened to the Cradock Four?
Yes, very much. Yes, very much. That they were planning to kill them, and that they were also planning for, and they were also anticipating the reaction that would follow the news of their murders.
My lady, in due course, we will put up the application before the Eastern Cape Supreme Court under that case number, as well as the amnesty applications of the security branch members for the murder of the PEPCO 3. And again, there's an overlap. And the lady, for example, Hermanus Baron du Plessis, also applied for amnesty in that matter. Now, Mr. Calata, you said paragraph 140.4 that a reinstatement and transfer are not steps that can happen as a matter of urgency. But you also point out another reason why it's unlikely to be that. Can you explain, well, Rob, perhaps you can say what you mentioned in paragraph 140.4.
Can you
just read 140.4?
Oh, okay. Yeah. All right. 140.4 reads as follows, Judge. A reinstatement and transfer are not steps that could happen as a matter of urgency, and had in any event been ruled out by the 23 May 1985 signal that stated that Goniwe and my father should never be reappointed under any circumstances to any position in the Department of Education.
Now, Mr. Calata, do you recall who authorized the signal of 23 May recommending that they never be appointed to any position again?
Yes, it was Brigadier van der Westhuizen.
And Mr. Calata, who authorized the 7th of May permanent removal signal?
It was Brigadier Joffel van der Westhuizen.
So you indicated earlier in your evidence that there was a distinction between removal and permanent removal. So can you give an example of what happened to your father and Mbelela Gqeberha and Matthew Gqeberha after the call for removal had taken place, and distinguish it perhaps from what transpired after the permanent removal signal was sent?
Excuse me. Judge, in the first case of a call for removal, when they said that they were agitators or something like that, the first removal was that they were detained on the 30th of March 1984. I think I had indicated to the court that my father and Lukhanyo were removed from the community and they were detained in a Deep Kloof prison in Johannesburg. Matthew Gqeberha and Madoda Jacobs, they were removed from the community and they were detained at Portsmouth Prison in the Western Cape. So the permanent removal was obviously very different, because in that instance, my father and his comrades, Mbelela Gqeberha and Matthew Gqeberha, who were on the signal, what then happened was that my father, Matthew Gqeberha, Sparo Mkhonto and Sicelo Mhlawumbe, they were permanently removed from society or from Cradock or from life.
And I suppose, Mr. Calata, one has to be careful with terminology, because even though the State Security Council requested, or at least the Minister of Black Education at that time requested the removal of the two teachers who were agitating, can you remind us what happened within 2 days of that request for removal? Just to jog your memory, it is in your statement a little earlier, but according to the amnesty application of Jaap van Jaarsveld,
yes,
he received an instruction from Head of Intelligence Security Branch Craig Williamson.
Yes. So Jaap van Jaarsveld, excuse me, traveled to Cradock, ma'am, and Basie Bouwer on the instruction of Craig Williamson, where to go and look at the Gqeberha home where we went to earlier this week. Jaap came back with a recommendation that said that it would be difficult to do it at home because it's busy, there's the community and all of that. And he made a recommendation that they be taken out somewhere along the way between possibly Port Elizabeth and Cradock. I'm not sure.
Mr. Calata, so earlier in your evidence, in fact, it was yesterday, and when I asked you whether you felt that there was a connection between the request for removal and that scoping exercise,
yes,
you responded yes, you saw a connection.
Yes, there is a connection.
So I just want to put it to you that even the word removal, assuming there is a connection, and we hope to hear from Mr. Williamson in that regard, but even the word of removal could be open to all kinds of interpretation.
Yes, of course, it could be open to interpretation, because the first time they were removed from the community and went to be detained, and then and then there was the second removal, ma'am, where they were removed permanently. So
just to conclude this section of your evidence, We expect that some of my learned colleagues for the former state officials might be submitting that this was just a private frolic by lower members of the security branch who just off their own bat decided to take out your father and the others. What's your response to the suggestion that this was a private frolic of low-ranking police officers?
That's absurd. It's completely and utterly absurd, Judge, that they would try to say that this was a private frolic of people, because Eric Taylor had no idea who my father was. Gerardus Lotz, again, he had no idea who my father was. There's no evidence, none whatsoever, that they'd ever met, that they'd ever spoken before. So what would Taylor have against my father? Why would he just randomly be part of a gang that murders a group of political activists from Cradock who had been discussed, that we know of, at state security level? It's completely absurd. And yes, we understand that defense lawyers and they must defend their clients, but it's absurd. Like it's just ridiculous that people would make the claim that Eric Taylor was on a private frolic. What kind of private frolics do they have? Because there's not normal private frolics, those men.
And if I can refer you to the State Security Council meeting of the 10th of June 1985, and this is just 3 days after the sending of the signal. Deputy Law and Order Minister Flock says that there are certain problems and he's going to take certain steps. Could you read into the record your paragraph 143, please?
143 reads as follows, Judge. As pointed out by the advocate, just 3 days after the sending of the signal, Flock reported to an State Security Council meeting held on 10 June 1985 that he had spoken to the chairpersons of the Joint Management Councils, and they had problems with departmental representatives not having the necessary mandates or delegations to act on their own initiative. He advised that the Secretariat had now arranged that if such action is urgently necessary, the chairpersons of the JMCs will present their plans directly to the departments concerned at a meeting in which he, the Deputy Minister Flock, will also be present, and where departments will then discuss the best course of action.
My lady, the minutes of that meeting at item 26 of the Calata bundle, pages 252 to 256. So, as usual, the terminology used is cryptic, but if you were to offer an interpretation as to acting on their own initiative, how would you view those words?
That they didn't need permission for every action that was required. That they, from henceforth, that they could at their level make a determination in terms of the best course of action that needed to be taken, and that they would then have to implement that course of action, that basically that they could take their own initiative, that they didn't need this permission of having to go up the chain of command and then wait for some kind of response and then implement that, that they be empowered basically to take what they consider to be the best course of action. And if that entailed murdering people, then I suppose so be it.
In your next paragraph, you raise a further possibility. You speak of plausible deniability.
Yes.
What did you mean by that?
So, if the JMCs or at their level could then make the decision and best course of action, it would then mean that the guys that are sitting at state security level, people like F.W. de Klerk and them, could then claim, but we didn't know anything about it. Plausible deniability, they could say that they weren't aware of whatever the foot soldiers were doing on the ground, but allowing them basically a free escape route.
Now, under a heading in your statement which you style as the smokescreen, you mentioned that through June and somewhat ironically even into July, after the murders, there's quite a lot of documentation looking at various other measures that could be taken, including further security detentions, as well as possible reinstatement, and that if he was reinstated, he could be controlled, in inverted commas. Do you think that was ever a viable option for purposes of controlling Matthew Gqeberha and his comrades?
No, of course not, because up until that point, man, they couldn't control him. When he was a teacher, working, fully employed, he helped set up the Cradock Residents Association. He helped set up the Cradock Youth Association. They were leading boycotts. They were doing all of those things while he was employed. So giving him his job back, how do you control a person? Even when with our best intentions, we can't control people. Advocate, if I may, I'm not sure if this would be the right place, and whether or not we would have that document. Ma'am, so when I was obviously doing my research to write our book, we had found a document, and I think I had handed it over to the advocates, where it was marked top secret, and in that document they talk about giving Gqeberha his job back, but that even giving him his job back did not exclude the security action against him. And then it states that the security action must be done in such a way, and it kind of loses its meaning a little bit when translated into English, but for the purpose of the court, I'll stay with English, where they say that the security action must be done in such a way so that the state won't just be able to defend themselves in court, but that they would do so successfully. And that's always been a thing that has bothered me, ma'am. And I know we're talking about the smoke screen, but that document comes to mind for me quite a lot, and I'm hoping that our attorneys would be able to assist, because it speaks to this issue of a smoke screen, ma'am, that they were preparing to the extent where they were saying that whatever security action we take, it must be done in such a way that we not only defend ourselves in court, but that we do so successfully. I'm hoping that they'll be able to help you with those documents.
Yes, we will supply the ladyship with the reference to that particular document. And while we're on it, Mr. Calata, in your view, what did they mean by dealing with the possible court action or legal action successfully? And in your view, what would be the nature of that court action?
Ma'am, if they'd re-employed Lukhanyo and potentially my father into their jobs, there would be no need for court action because they're getting their jobs back. If they detained them again for however long a period, there would be no need for court action because they'd already detained them in 1984. And when they were released in October '84, they didn't come back and lodge some kind of legal case against their defense. So the only time when they would, as far as I'm concerned, the only time that they would need to defend themselves successfully in court is that if they did something wrong. And in this instance, doing something wrong would be killing them. If they had transferred Matthew or my father or whatever the case may be out of Cradock and banished them like they did Umama Winnie Mandela to Brandfort, they would have not needed any court action. They would not needed to have defended themselves in court. So as far as I'm concerned, that document they were talking about, once they killed them, they needed to be able to successfully defend themselves in court. Hence everything that we've seen. The car being burnt, their bodies being distributed all around Port Elizabeth, because all of those things, in my opinion, was around fulfilling that requirement that they must successfully defend themselves in court. And they did so, ma'am, with the first inquest. They defended themselves very successfully in court. And they did so again in the second inquest, where they defended themselves successfully in court.
Thanks, Mr. Calata. So you seem to be suggesting that the security branch had a tried and proved method of dealing with court action arising from these kinds of operations. I'm just checking with my junior whether he has the reference to that document. Milady, I'm advised that currently that particular document is not in the States bundle, but it is in the civil application to compel a decision in this matter, which was launched in 2021. I was under the impression that was in the States bundle, but to the extent that it isn't, we will make sure that it is handed up. And my lady, we intend to lead our private investigator, Brigadier Marion, to closely analyze the documents and for him to offer his interpretation, although that won't be done in this session, my lady.
All right, understood. Except that I think it will make it difficult for any party who intends cross-examining the witness also, because there's very little information about the document, who compiled it and all that.
Yes, we will circulate the reference to this particular document so that they have it at least later today.
All right.
And my team, I'm sure, will really start on that. So turning to the smoke screen, or perhaps let me at least just give the title to the document. It's titled Voorgestelde optrede teen Matthew Gqeberha, Swartman Oud, onderwyser, Cradock. It's dated 25 June 1985. And, just 2 days before the murder itself. It is Annex LC19 to the application to compel a decision from the NPA, which was launched in July of 2021. So, Mr. Calata, you had the section in your statement from paragraph 145 onwards, where you referred to this interesting parallel development you call the smoke screen, which looked at all these different deliberations, including possible reinstatement. And you also make reference to the involvement of officials from the Department of Education and Training. And you say it's possible that the personnel involved in these exchanges were entirely in the dark as to the real plans in respect of Gqeberha, that you said 145.2 of your statement. Why do you say that?
Again, Judge, as part of this mission to obviously defend themselves successfully in court, the officials within, the Department of Education and Training, they weren't security officials. They weren't, part of the security apparatus of the state. So they probably would have been going on the assumption that yes, there are discussions to reinstate Matthew, and we might be reinstating him, and they were probably, these weren't securocrats, Judge, these were the people involved in education. So they probably would have worked under the assumption that Matthew and my dad will be given their jobs back, they'll go back to teaching, and there'll be some form of way in which they continue to be surveilled and all of that, while the people with the actual dark hearts were busy putting their plans in place, to remove them from society. This is my understanding. So these two parallel processes were then running, because I'm not sure if the ones that have no murder in their heart, were busy thinking he's going to be reinstated, and the ones that had murder in their hearts, they were planning their own missions.
Thank you, Mr. Calata. Milady, my junior has reminded me that the document is in fact in the possession of our learned friends. Milady, over the weekend, we had put together an index and a bundle which we called Outstanding Documents. Milady, these were documents that we didn't think were reflected in the latest index that had been circulated by the NPA. A copy was sent to your ladyship, as well as the state and all the parties. With the leave of the court, we would like to hand up this bundle to your ladyship as a temporary bundle, pending the full paginated bundle we expect to get on Monday. My lady, the document in question that I've just quoted is at page 475 of this bundle.
Would there be any objection to the handing up of this bundle of the so-called outstanding documents?
No objection.
You, Mr. Ngwaito?
Nothing from
All right, thank you.
The only problem is we haven't had the opportunity to read through all those pages.
All right, that has been noted. Thank you.
Well, if we, since this document has been read specifically by the witness, can we refer your attention to page 475? It's not a particularly long document. And Mr. Calata, carrying on, you make reference to one of the amnesty applicants, Captain Jaap van Jaarsveld, on the question of a smokescreen. Can I ask you to read that excerpt? It's in on paragraph 145.3.
Yes. Judge, paragraph 145.3 reads as follows. In his amnesty testimony, Captain Jaap van Jaarsveld, application number AM 3761/96 and decision number AC/2001/76 disclosed how the apartheid state security apparatus often used disinformation and propaganda to create smokescreens to disguise what was really happening.
Thank you. Now, let's just assume for the moment that the version that this was a private frolic was the case, and the murders of these high-profile activists took place. If in fact it was a private frolic, and it caught the senior officers at EP Command in Port Elizabeth, at the State Security Council, caught them completely off guard. They had anticipated a transfer or something innocent of that nature, but in fact brutal murders took place instead. What would you have expected to have happened in those circumstances?
Judge, I would have expected that the seniors would have acted to reprimand the people involved. I would have expected an inquiry, people would have been called in, and that people would have been, hauled before the courts, and that the state would have done as much as it could to distance itself from the actions of those few individuals that had obviously killed my father and his comrades. And again, ma'am, I work in television, and if I can just make a small little anecdote, ma'am, when I used to work as a program editor, I had once spelt the word calendar incorrectly on TV. It was calendar in English, but I had spelt it with ER at the end, as they do in Afrikaans. My managing director at the time, immediately after we were done with our show, she called me into her office, and I had to explain to her why I had spelled the word calendar incorrectly. And that was really, ma'am, just it was misspelling the word calendar, because we're in a rush. We do things very quickly in television.
On a frolic of your own, you decided to spell calendar.
Ma'am, it was a genuine mistake, but it was a frolic of my own. Now imagine, ma'am, when someone's life is taken, I would have imagined that if it was a frolic of their own, that the action taken against those people involved would have been would have been so much harsher because someone's life was actually involved, and there's nothing more precious in this world than life. But we didn't see any of that. We really didn't see any of that.
Thank you, Mr. Calata. Can we turn now to your quest for justice, what you and your family have done over the years to get to the truth, to get to justice and closure. You've already advised this court that you produced a short film called The Unfinished Business. I'm correct. And you've also written a book together with your wife Abigail titled My Father Died for This. Can we also talk about other efforts that you've made over the years? And you're not confined to your statement. If you can recall other things you've done, please feel free to relate those. But I noticed from your statement, from paragraph 147, that you went to see the then Deputy Minister of Justice, John Jeffrey, and you had quite an exchange with him. Can you describe to the court what that exchange was about and how you felt about it?
Ma'am, it was in 2017. We were busy doing the research for the book that we were going to publish. And as part of that, I asked the former Deputy Minister, John Jeffrey, for an interview. He agreed to the interview, and we sat and, we had a 2.5 hour long conversation. As part of that conversation, I asked the Deputy Minister then about, their failures to prosecute people in the Cradock Four matter. And the Deputy Minister said that, these issues of the TRC, including the Cradock Four matter, was part of, the price that had to be paid, for the negotiated settlement. When he said that, ma'am, obviously, like everything within me, like my blood was boiling. Because what did he mean that this was part of the price that had to be paid for a negotiated settlement? Because whoever went to go and negotiate with and using my father's life did not have our, as a family's, mandate. We didn't care about whatever deals the politicians had made using my father's life. They did not have our mandate. And you could not use my father in whatever negotiation that you entered into. We as the family, we wanted justice. And I was not prepared to accept that my father was used by politicians in some kind of, as a pawn, in some kind of negotiating game. And I pushed him quite hard for that, with that. But his standard response was, if this was the price that we paid, and we're sorry, but this is what was needed to get done at the time.
And you also point out in your statement that the Deputy Minister explained that there were so many cases they had to deal with and the government lacked resources. Yeah. What was your response to that?
Yeah, again, ma'am, it was none of my problem that the government lacked the resources. Really, it was none of my problem. My father was killed alongside his comrades, Matthew Gonewa, Sparom Contest, Dolom Cloud. It is the government's responsibility to be able to give us justice. Ma'am, if I don't like the education that my son gets at a public school, I can send him to a private school. If I do not trust public hospitals. I pay a lot of money for medical aid so that if I get sick or my son or my wife gets sick, I'm able to at least take them to an institution where they're likely to get the necessary medical assistance that they need. But I can't go to a private prosecuting authority to give me justice for my father. The National Prosecuting Authority is responsible for that. So if the state then can't give us justice, where must we go, Judge? Where must we go if the state fails in its responsibilities to give us justice?
Mr. Calata, you point out in your statement that the Deputy Minister said, well, funds are needed to build a functioning justice system that can deal with present-day crimes. What was your response to that, and why did you refer to the annual reports of the Office of the Auditor General?
I'd actually forgotten about that. Because it was important for me at the time, man. To say, but the state, it can't make a distinction between today's crime and a crime that happened 40 years ago. Justice is justice, and the state has got a responsibility to serve us justice in both of those cases. I had raised the issue around the Auditor General and her reports to prove a point that the state, there was such a lot of corruption, and then money was being misappropriated, money was being misspent, people were stealing it. And if they, as the state and the various departments were actually serious, that they could redirect those funds to help build the kind of society for which my father had sacrificed for. And part of that society has to be justice. And if money that's allocated for the Justice Department to be able to do its job, to deliver the services that it has to, then those monies must be spent in the appropriate manner, so that we as the population, as the nation, can have the justice that we require. And I think it was in that context that I brought up the fact that, but the Auditor General says you guys are wasting money and stealing it and being corrupt and doing those kinds of things.
Thanks for that explanation. Now, also in 2017, there was quite an historic reopened inquest into the death in detention of Ahmed Timol. Now, perhaps during that inquest or following that inquest, what steps did you decide to take?
Well, we were greatly encouraged by the reopening of the Ahmed Timol inquest, man. And the fact that the reopened inquest was able to overturn the findings of the first inquest, and that it found that, in fact, Ahmed Timol, didn't jump out of the 10th floor, but that he was actually pushed out of it, and that inquest had recommended that João Rodrigues, I think it was, that he be prosecuted. So, in that light, we then doubled down on our efforts, because we had been calling for justice for a long time. So we then doubled down on our efforts. Part of that was me meeting with Sean Abrams, who was then, I think he was an acting National Director of Public Prosecutions, because, we were hoping that we could have, some kind of movement in the Cradock Four case as well. I met with Mr. Abrams. I'm not sure about the date anymore, man, but I remember meeting him at the NPA's offices in Cape Town, because I still lived in Cape Town at the time, where he had promised, that they were going to look into it. The justice would come for us as the families of the Cradock Four. Yeah.
Just so you know, he in fact was he wasn't acting NDPP.
Yeah.
He actually was the NDPP at that time.
Thank you for that.
So I assume that nothing further came of that meeting, because according to your statement, you then decided to approach the Foundation for Human Rights and the pro bono team at Hofmeyr.
Yes, ma'am. Other than a tweet from Sean Abrams, nothing came from that. We then published our book in 2018, and shortly thereafter, I did then start speaking to the Foundation for Human Rights to assist us, so that they, because by then, ma'am, there really was no movement in the Cradock Four matter. None. It was almost like it had never even existed. So I then approached the Foundation for Human Rights. The foundation then assisted us by getting us in touch with the pro bono team from Gqeberha High Court, and we, now that we had, some support, legal people that were in our corner, and that we didn't have to pay, because we part of the pro bono, because, ma'am, if we had to pay, we would still be very far from where we are today. So once we were in touch with the team from Gqeberha High Court and the Foundation for Human Rights, we basically just kind of knuckled down and worked and pushed as hard as we can for us to be able to be here today.
And perhaps you can give a sense of what that team, including the private investigator Brigadier Marion, what they were able to do and who they were able to trace.
Sorry, Advocate. If I can just mention once, ma'am, as part of obviously this push for us to get justice, we had also met with the African National Congress. When I was fired from the SABC a couple of years prior, in 2016,
Please, let's take care of that.
Perhaps you can try switching it off, Councillor.
You can carry on.
Thank you, ma'am. So when I was fired from the SABC in 2016, I was then called to meet with the former Deputy Secretary General of the African National Congress, Jesse Duarte, the late Jesse Duarte. So in that meeting, I was able to establish direct contact with her and her office. So when I had started working with the Foundation for Human Rights, and we had other families also on board, such as Utendi Similane from the Noktula Similane family, Imtiaz Kaji from the Timol family, and there were other family members. We then also reached out to the DSG, as she was called, and we met with them with the team from the African National Congress on several occasions, where again, one of them was Ronald Lamula, who's the former Minister of Justice himself. He had attended some of those meetings. And in those meetings, we were appealing to them, for justice. We basically any avenue that I had, I tried to extract maximum value out of it. in terms of making sure that there was movement in the Cradock Four case.
Well, thanks for that additional step that you took. At paragraph 152, you point out that your legal team, together with Brigadier Clifford Marion, were able to trace individuals and determine who was living and who was not. Perhaps you can just read paragraph 142, at least 152 into the record.
Paragraph 152 reads as follows, ma'am. Extensive investigations were carried out by Marion, which will be described in detail when he's called to give evidence. 14 living persons of interest were traced, and the deceased status of some 21 persons were confirmed, while 14 persons could not be traced. Now, all information uncovered was handed over to the assigned investigators and prosecutors. More than 140 interactions and communications took place between Marion, my attorneys, and the assigned police investigators and prosecutors between 20 July 2019 and 2 July 2021. These efforts were aimed at supporting and enabling the work of the Directorate for Public Crimes and Investigations. I think that's what the DPCI stands for. I'm sorry, ma'am, it just excludes me now.
Directorate Priority Crimes Investigation.
Yeah, thank you, sir.
And my lady, that list or chronology is attached as LC 41 to that civil application, which will be part of the bundle that is handed up on Monday. Now, you also point to correspondence between your attorneys and Advocate Chris McAdam, who at that time was with the NPA's Priority Crimes Litigation Unit, the PCLU. And he advised on 23rd April 2020, and this is set out in para 153 of your statement, that a decision in the Cradock Four case could only be made once the investigations in the other TRC cases, such as Pepco 3, Motherwell bombing, and the Mkulu cases had been finalized. What's your response to the information you received that the MPA is saying that your case must wait until several other cases have been finalized?
Again, Judge, in that instance, I couldn't believe that what we were hearing from the NPA. Why was the Cradock Four case and a decision on the Cradock Four case dependent on what happened in other cases? The Pepco 3 matter is as important a case as that of the Cradock 4. And all of the other cases, the Motherwell bombing matter is as important a matter. But one does not necessarily depend on the other, because whatever happened in the Pepco 3 matter, other than perhaps the proximity in time, and maybe they were the same people involved, but the Pepco 3 matter is the Pepco 3 matter. And a decision on the Pepco 3 or on the Cradock 4 can't depend on whether one other case is finalized or not.
Hence you objected to that proposal?
Yes, ma'am. Of course, we disagreed completely, because, I mean, I thought it was another way of them just stalling, because it's ludicrous, ma'am.
And then you received even worse information. You say in your statement, paragraph 156, that your mother, on the morning of the 1st of April 2020, received a call from the investigating officer, Colonel Makua. Can you explain what that conversation was about?
Ma'am, I received a phone call from my mum telling me that she had just gotten off the phone with Colonel Makua. And Colonel Makua had basically informed her that the docket of the Cradock Four case was missing. Yeah, and again, ma'am, how does the docket go missing? It's not supposed to.
And because you say in paragraph 156 that your mother was emotional, you called the colonel.
Yes.
And can you explain what the colonel told you?
Yes, so I then did call the colonel and advise him that who I was and that I had just received a phone call from my mother and that please could he, talk to me or repeat what he had told my mother. The captain then told me that Advocate McAdam had advised him that the docket had been handed over to someone who claimed to have been sent by Advocate Nomgcobo Jiba, who was the former acting NDPP. Colonel Makua indicated to me that he was deeply troubled at what was happening with the investigation. He said to me that he did not believe that the docket went missing accidentally, and he was concerned that powerful forces were protecting the suspects, in particular the high-ranking suspects.
And what did Colonel Makua advise you to do?
He advised me to take up basically he told me that I needed to go to a police station and that I needed to lay a charge of a missing police docket.
And we'll get to that. Your statement reflects that you thereafter, on the 1st of June 2020, called the former investigating officer, Captain Masagela.
Yeah.
Why did you choose to call the former investigating officer, and what was your discussion about?
As part of that conversation with Colonel Makua, who had informed me of the missing docket, he had also mentioned, obviously, that he had done a lot of work, in that docket, and then that it was handed to him by the previous investigating officer who had since retired, Captain Masagela. Obviously, I called Captain Masagela just to try to understand what had happened. The one statement that struck me in that conversation was with Captain Masagela. He said that the prosecutors had failed him. When I inquired what he meant by this, he said every time he sent dockets through to the NPA for a decision or for guidance, they would take ages to come back to him, if they did so at all, ma'am.
So you then attempted to take the matter further as advised by Colonel Makua. And it's reflected in your statement that Cliftecker Hofmeyer engaged in several communications with the NPA regarding the status of the original docket and whether there was a theft investigation on the go. And at 162 of your statement, you say, without any meaningful response, I was left with no alternative but to open a criminal complaint of theft in relation to that docket.
Yeah.
Can you explain to the court what steps you took and how that worked out?
Yes, ma'am. So by then anyway, by then I was still living in Cape Town. So I went to the Caledon police station, which is in central Cape Town, to go and lay or to open a docket or a charge of theft of this missing police docket. They gave me the runaround there, ma'am, in that the guys in Caledon said that because the docket had allegedly gone missing in Pretoria, I think, so I couldn't open a case in Cape Town, that I needed to go all the way to, I think, to the Silverton or Silverton police station to go and open a docket. Again, ma'am, for me, I mean, it's insane. If I have to report a crime, or at least, why do I have to go to the nearest police station in Pretoria to go and open a case of a missing docket into the Cradock Four? Why couldn't I just be allowed to open the case in Cape Town and then they transfer the docket or the case from Cape Town to Silverton, and then for the guys at that site to start investigating and all of that?
So that you did on the 11th of September 2020, or you
Yes.
tried to do at least.
Yeah.
And because that didn't work out as you've explained, in paragraph 164, your attorneys made the attempt on the 1st of October 2020 at Silverton Police Station. And how did that work out?
My attorneys, ma'am, they tried to obviously then go and open the case in my behalf. They were also denied, ma'am, I suppose because they weren't me or whatever the case was, but they were also prevented from actually opening up a case at the Silverton police station.
In fact, they said something curious. They said that the attorneys, they couldn't accept it because only the Independent Police Investigative Directorate of South Africa could investigate that docket, even though it didn't go missing from the police, it went missing from the NPA.
Yeah.
And then your attorneys were forced to take further action, which you set out in 165. What steps did they have to take to eventually get a case opened?
So my attorneys addressed a letter to the Minister of Police as well as the National Commissioner of Police, ma'am, seeking their intervention. And once they had stepped in, this eventually resulted in the DPCI confirming in a communication on 23 October 2020 that a criminal case had indeed been opened for defeating the ends of justice and theft of a docket as per Silverton. And then they gave us the following case number, CAS 88-10-2020.
Now, to cut to the chase, we know that investigation did not deliver any answers, but we do know from an affidavit filed by Advocate McAdam in the litigation that you launched in July of 2021. McAdam filed an affidavit, the lady is reflected in paragraph 166, although that date can't be correct because it says 24 May 2021. We'll get the correct date to your ladyship. But just disregarding the date, Mr. Calata, can you read into the record paragraphs 166 and 167?
Yes. Judge, paragraph 166 reads as follows. Advocate McAdam filed an affidavit dated 24 May 2021, but that will be corrected, as part of the NPA's Rule 53 record in case number 35447/2021 Gauteng Division. In this affidavit, he indicated that during April 2013, he was Deputy Director of the Priority Crimes Litigations Unit, and Advocate Sean Abrams was the acting head. They received a request for information about the Cradock Four case from a Miss Lipinka, who was the personal assistant to acting National Director of Public Prosecutions, Advocate Gqeberha. Abrams responded to the request, and shortly thereafter, McAdam was asked to hand over the investigation docket, Swartskop CR 13/07/1985, to the office of the acting NDPP, which he did. McAdam then avers that at a certain stage, without disclosing a date, that Advocate T.P. Pretorius SC, then acting head of the PCLU, asked him for the Cradock Four docket, and he advised Pretorius that it had been uplifted from our office and was missing. McAdam did not disclose why Pretorius was seeking the docket. This exchange must have happened between 2016, when McAdam returned to his normal duties after working on foreign bribery cases, and April 2019, when he assumed the position of acting head of the PCLU.
Thank you. Milady, we will get you the reference to the affidavit of Advocate Christopher McAdam in the Rule 53 of the civil application. I've just noticed that in the outstanding documents index, the wrong McAdam affidavit is reflected. That's an affidavit he filed in the Rodriguez application for a permanent stay of prosecution, but we will locate the reference for the Rule 53 affidavit in due course. In the meantime, I can refer this Honourable Court to the supplementary founding affidavit that Mr. Calata filed on the 26th of October 2021 in response to Mr. McAdam's affidavit, and that's at page 587 of the outstanding documents bundle. Now, you say in your statement that from what was said in Advocate McAdam's Rule 53 affidavit, it was evident that no investigations on the Cradock docket occurred between 2013 and 2019 when Advocate McAdam took steps to assist the investigating officer to reconstruct the docket. That was a period of some 6 years. What's your reaction on learning that between 2013 and 2019 there was no docket available upon which to carry out investigations?
Ma'am, by then, I think it was obvious to everybody that the case of the Cradock Four was quite a significant and emblematic case in South Africa over the years. You heard yesterday, ma'am, that it really, on the afternoon of the Cradock Four's funeral, the government of P.W. Botha had declared a state of emergency. I had, over the years, because of my job, I'd met several senior and high-profile individuals, and most of them, once they would always ask me if I was related to the Calatas from Cradock, and when they would ask me if what my relationship was to Fort, And whenever I would tell them that, Fort was my father, many of them would actually recall that, hey, I was in Cradock that day, and then they would then regale me with stories. Sometimes I wouldn't have the time because I would be there in my capacity of a journalist, so I would have, kind of play nice and say, yes, but I'm here for work, but neither. Anyway, man. So for me, what had become clear was that between 2013 and 2019, nothing, like absolutely nothing had happened with the Cradock Four case. There were, whatever investigations there were, had stalled because nobody knew where the docket was between 2013 and 2019. So nothing happened, like absolutely nothing happened with the case. Whatever investigations Makua and Masekela had made prior to that had basically been in vain because the case was, the docket wasn't even, they didn't even know where the docket was, man.
Thank you, Mr. Calata. Milady, just going back to the affidavit of Christopher McAdam, we have located it. It is at page 1255 of the outstanding documents bundle. So that would be, I believe, the second volume that we've handed up to your ladyship. And I see it is in fact dated 25th of May 2021. So I'm assuming that Mr. McAdam made out that affidavit as part of the police investigations into the missing docket. Now, at paragraph 170 of your statement, Mr. Calata, you make reference to Advocate McAdam's affidavit, where he says in his statement that the missing docket only comprised of an inquiry into unfounded rumours around one General Hankel, and in the Inquest and TRC records, which were easily re-obtainable. And then you point out in your statement that, well, if that's all the docket contained, as suggested by Advocate McAdam, then it reflects that little or no investigation was taking place because there, besides the publicly available records, there was next to nothing which suggested an investigation. And you said that means that there has been no real substantive investigation in this matter for more than 20 years.
Yeah.
When you learned that, what was the impact on you?
So, as I had mentioned earlier, Judge, we, from about 1995 onwards, when Madiba came to Cradock, we were certain that justice was going to come in some form or the other. But then nothing had happened. Absolutely nothing had happened. And when we were speaking to the NPA and McAdam and everybody else, and it became apparent to us that even the docket had gone missing, ma'am, it almost like snuffed most of the hope that we had, really, because it just proves that people weren't interested, that people didn't care. They were busy with democracy and corruption and all of those things, but they didn't care in terms of how we got that democracy.
So, moving on, it seems that you decided to take some steps. You point out in paragraph 172 of your statement, why you decided to institute litigation in this matter. Perhaps you can read paragraph 172 into the record.
Page 172, paragraph 172 reads, some 2 years after liaising with the NPA and the DPCI and twice placing them on terms during 2020 to finalize the murder investigations, it became clear that the NPA and DPCI were making very little headway. The Cradock Four families instructed our lawyers to launch an application to court for an order compelling the authorities to finalize the missing Docket investigation, as well as to take a decision on the murder case. This application was launched on 20 July 2021. That was to mark the 36th anniversary of the burial of the Cradock Four. Ma'am, can I just state also that by then I now had legal backing. I had lawyers, and I was basically prepared to give the government a punch in the nose because I didn't know what else to do. So, and that's what we set out to do.
So, through this process, you and the families were able to extract documentation from the NPA and DPCI in the course of the review process. And you set out in paragraph 174 that this disclosed the dire state of the investigations, but it did force the prosecution and investigation teams to work closely with the family team, and that then resulted in the litigation being held in abeyance. But by then, suspects were elderly and dying off. And in fact, we'll get to that shortly. But you note the death in May 2023 of Hermanus Baron du Plessis, the last remaining suspect against whom there was a prima facie case. So with his death, talking of a punch in the nose, what was the impact on you hearing about that?
Judge, the death of Hermanus du Plessis was a punch in the gut. Because up until that point, there were still suspects where there was prima facie evidence against them that could be prosecuted. So, if I can just recall the day, Judge, when I went to the office and got to the office, set up, opened my laptop and then started working, and then just as I was about to work, an email came in, and the email was from our lawyers from CDH, basically saying that Hermanus, the last suspect that we, for an actual prosecution had died. Now, up until then, ma'am, I was really operating like tunnel vision, like this, and I was just pushing for a prosecution of some kind, because that at that point would have been justice to us, someone being held accountable for the murders of the Cradock Four. I think by then we had had some encounters with Advocate Yanni Coltman, and he'll tell you, man, that sometimes I'm not a very easy person to deal with. So when I got that email, my heart started racing, like do. I struggled to breathe. I didn't like. I got drowsy at my office. And I didn't know what was happening, ma'am. And fortunately for me, my managing editor at the time, Zain Samar, he had a good eyesight to where I was, and he saw that there was something wrong with me at that time. So he came to my desk, and we spoke a little bit, and I was in between breaths. I was able to explain that I can't breathe. And then he took me out of the office, took me to the boardroom, and where he managed to calm me down. And I thought I was having a heart attack because I had a massive pain in my chest, and then he said I must go home. I called the doctor, and fortunately she could see me, and I calmed down a little bit. I went to get my car and I drove myself to the doctor. And I got there and I was telling her my symptoms. I couldn't breathe. My heart was racing. There was almost something was pressing on my chest. And she did tests. She put stuff on me. A whole lot of tests. After about half an hour, she came back with those tests, and we sat, and she told me that physically I was fine. My heart was in rhythm. Like my blood sugars and stuff, they were all within the limits. I was good physically. But then she said, but what happened? And that it sounded like I had a panic attack, and she asked me what happened. So then I explained to her that no, I received this email, and it said that the last suspect in my father's murder had died, and that his death meant that justice in the traditional sense of somebody being held accountable for my dad's murder, that door was now closed to us. And the doctor, bless her heart, she said to me that I had a hole in my soul that needed healing, ma'am. And she asked that I see a counselor. And from...
You want to carry on, or would you like to take some time?
I'll be fine.
Don't you want to take a seat? It's 5 to 1. Would you rather take the lunch adjournment at this stage?
Milady, yes, it is almost 1. We're not far from the end, but maybe this would be an appropriate time for the lunch adjournment.
Okay, could we adjourn for lunch? All right.
Usapha and Mr. Nava requested that they should be excused. They must still drive back to Mthatha.
Okay.
As a-
And how does one get hold of the social workers? Should that be required?
They can come through me
All right.
and then I'll give them. Thank money.
Thank you, Mr. Mbandana. Thank you, Mr. Mbandana. Yes, Mr. Valley.
As the court pleases.
Are you feeling better now, Mr. Calata?
Yes, ma'am, I am. Thank you very much. Thank you.
Milady, we don't intend to be much with Mr. Calata. We have to conclude his evidence in chief quite soon. Mr. Calata, you have a section in your statement which is titled Fading Prospects of Truth and Justice. And at the beginning of your evidence, you already alluded to the fact that you believe there have been political interference in the investigation of the TRC cases, including your father's case. And in paragraph 178, you make reference to the fact that your legal team identified around 49 persons associated with the Cradock Four case in one form or another, and that many of them have died. Can I ask you to place on record the known deaths of persons of interest? And you could simply read from paragraph 178.1 through to 3.
All right. Thank you. Judge, from 178.1 paragraph, it reads, all 6 members of the police hit squad who murdered the Cradock Four have died. All the masterminds against whom there was prima facie case have died. Most of the members who sat on the State Security Council between 1984 and 1985 have died. Since we launched our application to compel the National Prosecuting Authority and SAPS to finalize their investigations in July 2021, the following persons of interest have died. Eric Winter, the former Cradock Special Branch Commander. He died on 18 August 2021. F.W. de Klerk, the former State President. He died on 11 November 2021. Johannes Velder van der Merwe, the former SAP South African Police Commissioner, died on 27 August 2022. Adrian Flock, the former Minister of Police, died on 8 January 2023. And Lucas Daniel, nicknamed Neil Barnard, former Director of the National Intelligence Service, died on 13 January 2025. Hermanus Barend du Plessis, the former head of the Special Branch's Black Affairs in Port Elizabeth, died on 16 May 2023. He was the mastermind behind the gruesome murders of the Cradock Four. The PAPCO 3, Spiwam Timkulu, Topsi Mataka, Nogcinisizwe Kondile, among others. All were tortured and abused before their deaths. It is, Judge, unforgivable that the authorities allowed du Plessis and the others to go to their graves without ever facing justice.
Melody, I'm reminded that we did actually put this on evidence on record yesterday, but I suppose it never hurts to be reminded of that tragic history. Now, Mr. Calata, do you have a concern that the remaining former state officials or so-called persons of interest may not get to testify even before this hearing?
Yes, Judge. We are very concerned that most of the persons of interest, those that are still alive, could die before coming here. They are all elderly, and every day that passes is obviously an opportunity missed for us to be able to hear from them. But it's perhaps a day closer to them passing.
And perhaps I can ask you to read into the record who they are, together with their ages, from paragraph 179.1 through to subpara 6.
Judge, Gerrit Nicholas Erasmus, the former Lieutenant General and head of the Port Elizabeth Security Branch, is now 88 years old. Baron Jacobus du Plessis, the former Minister of Black Education and a member of the State Security Council, is now 85 years old. Isaac Johannes Krappies Engelbrecht, who is the former Major General and head of the South African Police's Counterintelligence Department, is now 84 years old. Christoffel Pierre Joffel van der Westhuizen, the former Lieutenant General in the South African Defence Force and former officer commanding in the Eastern Province, is now 82 years old. His legal representative has disclosed that he is in poor health. An attempt to take his evidence on commission has been stymied because the South African National Defence Force refuses to pay his legal costs. Craig Michael Williamson, who is the former head of Security Branch Intelligence, is now 75 years old. And Eugene Alexander de Kock, who is the former head of the Security Branch's Vlakplaas unit, he too is 75 years old, Judge.
Thank you, Mr. Calata. In the last section of your statement, you deal with the trauma and impact your father's murder, together with the failure to follow up the Cradock Four case, has had on your life. You mentioned in your statement at paragraph 187 that the long-standing silence of the government and ruling party on the suppression of the TRC cases has been deafening. And you refer to a quote from an ANC official. Please can you read that quote into the record, explain where it comes from and why, and your response to it.
Advocate, please help, because
Yeah.
the quote I can't seem to remember, because I'm trying to think of
Okay,
it.
so it's at page 187
Yeah, page
And
Page
61.
and page 61 at the bottom of the page.
Yeah.
And my recollection is that official made that statement after, or rather in the documentary made by Al Jazeera.
Oh yes,
Yes.
yes. I remember now. I was trying to think of another one. If I recall, the statement in the documentary was made by an ANC official, Krish Naidu, who was had been part of those meetings that I referred to earlier, Judge, that we had with the African National Congress and the late Deputy Secretary General Jesse Duarte. And in the documentary the council is referring to, Mr. Naidu refers to cases like my father's, and I quote, "They simply fell through the cracks." End quote.
And what was your response to that statement in that documentary?
I failed to understand, Judge. I really failed to understand just how flippant the African National Congress, and from all levels, Judge, whether it's Krish Naidu, who sits on or assists the once governing party of its legal department, and he sits there, whether it's someone like Upumbula Lukhanyo, who was once the chief whip of the African National Congress, who sat in Parliament within arm's length at times of former President Thabo Mbeki, or any of Mbeki or Zuma's administrations. It really astounds me at just how flippant they could be around something that is so important to us. We lost our fathers, Judge. Our mothers lost their husbands. The people who brought us into this earth, we lost them in the pursuit of this democracy that we enjoy today. But yet, it seems that within the African National Congress itself, there's a disdain, there's a flippancy as to justice for the people who sacrificed their lives for our freedom. And when I heard this in that documentary, I was really like, I'm really astounded, Judge, because I genuinely failed to understand. Can I just add also that I had also, Judge, had a very brief conversation once with the Reverend Frank Chikane. He had been at my previous place of employment, and I had about 15 minutes with him. And I'd asked him, why they were never interested in pursuing justice. He said to me in that conversation, do I want the truth? I said, yes, of course I want the truth. Then he said, well, there was never any appetite to pursue these cases. So, the Reverend, who was a Director General in former President Thabo Mbeki's presidency, in his office, Krish Naidu, who works in the ANC, one says there was never any appetite. One says, well, it simply fell through the cracks. Former Deputy Minister of Justice, John Jeffrey, says, oh, well, it was part of the negotiations. This was the settlement. And I could mention others, and there have been many. We've asked ourselves, for instance, Judge, and that maybe you could satisfy yourself when Upumbula Lukhanyo comes and he gives evidence. You could satisfy yourself in terms of what he did in this regard. He served in Parliament from 1994 all the way to 2007. We had pinned such a lot of hope on him being in Parliament, on him being this close to the actual decision makers. As the Chief Whip, we had hoped that he would try and push our matter forward. But nothing happened. And it doesn't seem as if the African National Congress was ever interested in giving us justice. We've had to go to court. We've had to threaten legal action. We've had to do all of these things just to get justice, Judge.
Thank you, Mr. Calata. Malodi, there is a statement in the Lukhanyo Calata bundle from Hamilton Wende, the producer and director of that Al Jazeera documentary. It's at page 249 of that bundle. And it confirms that he interviewed Mr. Krish Naidu, who made that statement, as well as he confirmed that he interviewed Adrian Vlok. We intend to call Mr. Wende. We don't have a date at this stage as to when he will appear before your ladyship, but he will be called. Malodi, I'm about to finish up, but my junior advises me that he has to leave for the airport. May he be excused?
By all means, he may be excused.
Thank you, Malodi.
Yes, Mr.
As the court pleases. You also mention page 188, rather paragraph 188 of your statement, that it took the launch of a major application to court for constitutional damages in January this year to get a reaction out of the government. What does that tell you, Mr. Calata? What conclusions do you draw from?
Ma'am, it tells us that unless forced into action or forced into a decision, the government of South Africa matters relating to TRC cases. And it seems that the only route that we now have is through legal means. When we had managed to persuade many other, well, it wasn't that difficult. But when we spoke to these other families around joining our cause of launching this for a commission of inquiry to try to vindicate our constitutional rights, only then was there be heard. Because then all of a sudden the office of the president was prepared to negotiate. But we had been writing letters, we had been petitioning, asking for meetings with the president. I think and the council can correct me here, but I think the first one we sent was in 2019 to try to get to just have a meeting with the president, or at least for us to be able to raise our matters with him in person. But it only took, they only responded once we went to court. And only then it was also to, I suppose, to politically manage the situation so that a government led by the African National Congress could not be seen to be fighting with the families of, I suppose, martyrs in public like that. So they're trying to stage manage or politically manage their response.
Thank you, Mr. Calata. Just before we wrap up, can I ask you to read into the record the last two paragraphs of your statement, paragraphs 189 and 190?
189 and paragraph 190 reads as follows, Judge. In many ways, the brutal murder of my father and his comrades has defined me. My choice of career as a journalist was motivated by the brutality and injustices visited on me and my family. I have made it my life's calling to search for the truth and to do justice to the lives of my father and his comrades, which were so brutally cut short. I will not rest until the last surviving killer has been held to account.
Mr. Calata, is there anything further you'd like to add?
No, Judge. Thank you.
Thank you, Mr. Calata. I believe that concludes the evidence in chief for Mr. Calata.
Thank you, Mr. Van. Mr. Kochman, does the state have any questions for Mr. Calata?
No questions.
Thank you. Mr. Murray-Toby?
Only friendly fire.
Okay.
Mr. Calata, my lady, we have a letter. I'm not sure how the NPA proposes to deal with it. We have a letter from the attorneys of General van der Westhuizen that are complaining specifically about the evidence of Mr. Calata. So I just do need to get direction. Or they'll address it after. All right. Thank you.
No, address it now.
Do you want to address it now? All right.
My lady, will leave the court. Unfortunately, I hadn't had a chance to speak to my learned colleague. During the course of the day, we received a communication from Mr. Ruas, directed to Mr. Colton and myself, regarding the ruling that had been previously made and was discussed in chambers by Mr. Skuman as well. Mr. Ruas and his counsel again reiterated their understanding of what your ladyship's ruling was, and they believe that it meant that no one could refer to their clients even if it relate to public documents. He requested that we bring that that letter to your ladyship's attention. The letter was only circulated to myself and Mr. Colton, but I have provided it to the rest of my learned colleagues. But I don't, unless your ladyship wishes for me to read the contents into the record, I can provide a copy to the ladyship's secretary as well. The gist of it is basically that he was of the understanding that no one could make reference to any of the persons of interest.
Okay. No need to read the letter into the record.
As court.
Thank you, my lady. I take it your ladyship sticks to her ladyship's guns.
Yes.
We've been through this road before.
Yes.
Thank you, my lady. That also liberates me. Mr. Calata, thank you for your evidence. It's, as I said, it's friendly fire. So Judge Zitzman found that the signal's meaning was killing. I know you debated that, but There's actually a judicial ruling that the meaning is unmistakable. It means killing.
Yes.
And there were 3 people to be killed. Matthew Goniwe, Mbulelo Goniwe, Fort Calata. Of those 3, 1 is still alive. And that is Mbulelo Goniwe. But not only did the judge find that the meaning of the signal was the killing of these 3 individuals, Adrian Flock, according to your statement, also said the same thing pretty much to a journalist, Hamilton Wende. That is in your statement at page 247. It's an annexure to your statement. But if you look at the last block, where the journalist says there was definitely an order that found its way into the State Security Council saying they must be permanently removed from society. What did that mean? So what does Mr. Flock say it meant?
Do you want me to read?
Yes, please.
Mr. Flock, you know, we in the Security Council, we were very careful not to tell, not to say, and not to make a note, and to have in the minutes to kill anybody. So we would say, remove a person from the society, remove him. And you know, never, nobody said killing, but I thought probably it was meant, if you can't solve the problem by removing the guy, then you could kill him.
Yes. Thank you. Now, in the light of the Judge Zitzman finding that permanent removal means killing, and the confession by Adrian Flock that the coded way of speaking was never to say kill, is there any dispute that you think can still arise as to the meaning of the signal?
No, no, Judge, because as far as we're concerned, when a court makes a ruling, that's the finding of the court. So in the inquest, when there was a ruling or a finding by Judge Zitzman, and then there was an admission by Adrian Flock, there can be no dispute, because now there's a finding by a court and there's an admission, so there can't be any dispute.
Yes. We shall see if anyone in this inquest is still going to dispute it. Now, you also mentioned F.W.D. Klerk as one of the persons of interest who died before he could face justice. Can you explain to her ladyship why F.W.D. Klerk is a person of interest? Because one of the things I picked up is that when he died in 2021, the Fort Calata Foundation issued a statement in which it said it's regrettable that de Klerk has been allowed to go to his graves without ever disclosing his role in the Cradock Four assassination. Can you just expand on that and focus on de Klerk specifically?
Judge, at the time of the murders of the Cradock Four, F.W. de Klerk was a member of the State Security Council. He was the Minister of Basic Education and Training that sat on that council. We understand that on the days when there were meetings of the State Security Council, and I'm hoping that the advocate would be able to assist us with the dates, in March 84, and again May 85, and in June 85, that Mr. de Klerk was in those meetings, and he had been called upon to say something, because my father, Matthew Goniwe, were teachers. So as the Minister of Education and Training at the time, he would have been allowed to have an input in those State Security Council meetings when they were discussing Koniwe and Calata.
This topic about FWD Klerk is of interest to us. In fact, should be of interest to every South African, because FWD Klerk's legacy in this country is one of being a reconciler and as a person who ended apartheid. But the picture we're getting from this inquest is actually that he may have had a role in the planning of murder.
Yes, Judge, that is our belief, that being a member of the State Security Council, there are signals that are sent to the State Security Council that specifically mention Calata no Koniwe. One is that they must never be appointed ever again as teachers in the department, and then the other calling for their permanent removal from society. We don't have the minutes of what Mr. de Klerk actually said in those meetings, Judge, but we do have records of him being in attendance at those State Security Council meetings. In terms of him being a reconciler, when Mr. de Klerk died, I had, Judge, for years been using public platforms, media and all of that, to try to call for some level of accountability. None came up until the day he died. Instead, Judge, what I wish to add is that after his passing, Mr. de Klerk's widow, Elita de Klerk, did reach out to me. And she did make an attempt at reconciliation between us. And I'm happy to report to you, Judge, that we are still in that process. At the start of this inquest, she had sent me a very beautiful SMS or WhatsApp message where she was wishing me and the rest of the family strength and hoping that this inquest will finally provide us with the justice and truth that we require in our journey towards healing and closure.
Thank you, Mr. Calata. There's also another name that you have mentioned. That's why I had to start with that letter. The name of General van der Westhuizen. Why is he a person of interest from your perspective?
General van der
Is this
West.
based on public documents?
It's based on the testimony of the witness that was led in chief.
But you must recall that the agreement was that as long as that evidence does not independently implicate a person of interest. If it's based on public documents...
Let me reconstruct the question. What do the documents show that could lead one to conclude that he's a person of interest?
Well, public documents
Yes.
presented in the second inquest by Judge Neville Zitzman show that in the military signal that was exposed in that New Nation article in 1992, that in that signal, Colonel Lawrence Duplessis mentions the name of Brigadier General Joffel van der Westhuizen as references a telephonic conversation between van der Westhuizen and I think van Rensburg. And then he states that as per that conversation, they are now recommending the urgently recommending the permanent removal from society of Matthew Goniwe, Mbulelo Goniwe, and Fort Calata. So on that basis, Judge, I say that General Yoffel van der Westhuizen is a person of interest.
Let's conclude this part by taking the judge to the actual documents. The documents would be in file 12, exhibit G42, pages 4,690 to 4,695. Okay, well, my lady has a lot of paper in front of her. All right, it was so easy to just pull it out. So if your ladyship goes to file 12, exhibit G42, page 4690 to 4695, I will give the witness my own document to make it easy. So Mr. Calata, you will see there that is a letter addressed from the Republic of Transkei by General Olomisa, who was the chairman of the Military Council, on the 7th of May 1992, to the State President of South Africa, who was FWD Klerk. And if you look at the attachment, it attaches a newspaper report.
Yes, I can see.
And would that be the New Nation newspaper report?
I believe it is.
Now, this is what it says.
At least a copy there.
Yes, this is a copy. Yes, it's a copy. So it says in the first column, my observation. This is a copy of a signal message from the Eastern Province Command of State Security Council Pretoria, sent by Staff Officer of Intelligence, LL Duplessis. So that would be Lawrence Duplessis.
Yes.
Yes. This message was transmitted on the 7th of June 1985 through the Eastern Province Command Signal Unit in Port Elizabeth and signed by Duplessis, whose extension telephone number was 112. This signal message was for the personal attention of General van Rensburg, who was probably one of the security personnel holding a key position in the State Security Council. And then it says the signal refers to a telephone conversation between General van Rensburg and Brigadier van der Westhuizen.
Yes.
That's what you were talking about.
Yes.
Yes. On 7 June 1985. If I can still remember correctly, Brigadier van der Westhuizen was commander of the Eastern Province Command at the time. And then it goes on. It is clear that Brigadier van der Westhuizen called L. Duplessis to confirm in writing the telephone conversation between General van Rensburg and himself, hence this written signal message. The most striking aspect of this signal message is paragraph 3, which categorically cites the urgency for the permanent removal of Matthew Goniwe, Mbulelo Goniwe, and Fort Calata. Yes. So in other words, there can be no controversy. The publicly available documents identify General van der Westhuizen as a person of interest.
I can agree with that, Judge.
Yes. Now, the way this was understood, you left that question halfway when you were answering, Mr. Van. It's one thing to say subjectively this is what we thought, but the way it was understood by those people who carried it out, what do you say about that? How did Winter, Taylor, the actual murderers, how did they understand the message?
Ma'am, they spoke Afrikaans. When my mother testifies, I'm hoping that she will inform this court of an actual conversation that she had with Eric Winter, who came to our house. My mother would be able to give details because when she tells the story, he sat on the bed and said something to her in Afrikaans. She can elaborate on that when she takes the stand. Permanent verwyder. Understanding that these were people who were trained to kill. understanding that these were people who held no regard for our lives, because again, Judge, we weren't human beings to them. I have no doubt that Winter, Taylor, Lotz, and everybody that was there on that night understood that signal to kill my father and his comrades.
Thank you very much. And yes, you've mentioned that they physically visited your family home. You will recall when we did the inspections in Loco on Tuesday and Wednesday, that they also visited twice the Gqeberha home. First, they went there to change the telephone line, pretending to be post office workers.
Yes.
But secondly, they just went on a surveillance.
Yes.
What does that tell you about the planned nature of these executions? The fact that they went to your home and they also went to the Gqeberha home.
Judge, what it tells us is that nothing about what happened on the 27th of June was random.
Yes.
Nothing about that was random. Winter went to our house. Jaap van Jaarsveld went to the Gqeberha home to go and scope it out. My mother will come and testify to this court what Winter said to her when he couldn't find my father at home. Nothing about my father's death and the involvement of the special branch of the South African police, of the South African Defence Force. It wasn't random, it wasn't a frolic.
Thank you. Then, moving away then from the clarificatory questions I had on the incident itself, I just want to explore just one theme, this idea of a price having to be paid for freedom. Just expand on that, because there can be a scope for misunderstanding about what you actually mean.
Well, there was the conversation, Judge, that I had with the former Deputy Minister of Justice, John Jeffrey. Because I was insistent on justice and pushing and trying to get to where people should be prosecuted, the former Deputy Minister said, well, there was a settlement, it was negotiated, you know, and this was the price that we had to pay. My understanding of that, backed up by, again, a statement that was released by the F.W. de Klerk Foundation, was that there was a deal that was put in place. It may not have been an official deal that was done in front of cameras or anybody, but there was a deal put in place that sought to prevent people like General van der Westhuizen from being held accountable for the crimes that they committed against my father's humanity, Matthew Goniwe's humanity, Stelo Mhlauli's humanity, and Sparo Mkhonto's humanity. That is, for me, that's as clear as day, Judge.
Yes, you see, the reason I say that there is a risk of you being misunderstood on this topic is that there was in fact a deal. It was the TRC.
Yes.
You see, you go to the TRC, you tell the truth, you don't get prosecuted. A lot of people disagreed with the idea of the TRC. But you seem to be suggesting that beyond the TRC, there was another secret pact.
Yes, Judge. Yes, I agree. I am saying that there was a secret pact. I was not in the room, Judge, but that statement by the F.W. de Klerk Foundation in July 2021, again, our team can assist with a copy of that statement. And when you see it, Judge, it's there, black on white, where the former president, state president of the Republic, confirms that there had in fact been a deal prior to the Truth and Reconciliation Commission. Eric Taylor, who had confessed to the TRC of having been the one to have physically snuffed the life out of my father, was denied amnesty by the Amnesty Commission for his role in the murders of the Cradock Four. But yet there was no investigation, there was no prosecution. He died in 2016 without ever having been held accountable. Not on one day, Judge, do I understand there to have been someone from the Hawks or the police to have gone to his house and taken a statement because they were investigating the murders of the Cradock Four and his role in it. There was definitely a deal.
Thank you, Mr. Calata. And then finally, again, that's something you sort of left halfway. This topic of justice. I mean, what does justice look like to you? When you say there was no justice, what would it look like? I know that this commission or this inquest is not really going to deliver the full scope of justice. Right? Perhaps other processes will have to be undertaken. But speaking for yourself, what would it look like?
Today?
Today, yes. They didn't prosecute them when they should have prosecuted them. Some of them are dead. We'll never recover them. The ones who are alive are 88. They're frail and weak. But we still need justice. So what would that look like?
There's several aspects to it, Judge. Justice, of course, would be for anyone that's still alive that can be charged and prosecuted, for them to be charged and prosecuted, and hopefully being convicted by a court such as yours, Judge, for the roles that they played in the murders of our fathers. In terms of this inquest, Judge, justice is the truth and the whole truth around everybody who had anything to do, directly or indirectly, anything to do with the murders of the Cradock Four, for their roles to be properly expanded on and for their names to be captured for all of eternity, so that nobody in another 40 years from now can deny that that is what their family members did to our family members. And then finally, Judge, justice would also be for the people of our country, both black and white, colored, Indian, Chinese, and everyone else in between, to honor our parents and their sacrifice by truly building the kind of society for which they had laid down their lives for. It would be incredible for us as families to be able to live in the kind of society where truly, the color of my skin matters as much as the amount of drops in the ocean, where we can just be individuals and be people, not defined by the colors of our skin. That, I think, would be justice holistically for us, Judge.
Thank you, Judge. Thank you, Mr. Calata.
Thank you. Yes, Mr. Mann. Any questions?
My lady, I would prefer Mr.
Skuman.
to address it
All right.
with regards to our position.
All right. Yes, Mr. Skuman.
Yes, my lady, I don't think it's necessary for me to once again go over the circumstances of the bundles and the legal representation that they haven't had the opportunity to properly peruse everything. My ladies, under the circumstances, we would request that we, I don't think Mr. de Kok would really have any questions for Mr. Calata, but I believe that Mr. Van der Westhuizen and his legal team, as well as my colleagues in front, would have questions, and under the circumstances, we would just request that cross-examination for this witness just be reserved until everyone had the opportunity to properly peruse all the bundles in order to meaningfully cross-examine this witness. As it pleases the court.
When do you envisage that could be? When the parties would be in a position to cross-examine the witness?
Well, I believe we would be ready early next week. I cannot speak for Mr. Van Zyl and the person of interest, Mr. Van der Westhuizen, but from our side, I believe early next week we will be ready to proceed with cross-examination of this witness.
Okay.
As it pleases, my lady.
I must place on record I'm in agreement with Mr. Lukhanyo. I would just like to thank Mr. Goldman for sending the documents to me in August last year. I was not on the record then. But he said he'll give it to me now. Thank you.
Yeah. You don't want to add anything?
No, my lady.
It does sound to me to be fair enough. I do not know whether there is anyone with an objection to the proceedings being adjourned at this stage and for further cross-examination or for cross-examination to be reserved. Mr. Coulterman, any objection?
None. I agree with it.
Mr. Ngaitobi, would you have any objection to that?
I just wanted to ask if anyone here is speaking for Brigadier Van der Westhuizen or not. I'm no longer sure. I know my learned friend Mr. Skuman is for Mr. de Kok, because the problem is that correspondence we got now that needs to be factored into any decision.
Right, please the court, my lady. So, no, my lady, technically we are not speaking for Mr. Van der Westhuizen, but yesterday we did inform Mr. Van der Westhuizen's legal representatives of the ruling that was made, and I think subsequent to that they sent email correspondence from their side. But also Mr. Van Zyl also asked me that if this proceeds, that we at least for them as well reserve their right to cross-examine this witness.
Okay.
As it pleases.
Monday is early next week. Or
Yeah.
by early next week, what do you think? Do you think you'll be ready?
I say that's the earliest of next week, Your Worship.
The earliest of
As
next
the court
week.
pleases.
Do you think we'll be ready to cross-examine on Monday?
Yes, definitely from our side we will be ready. I'm not sure about my learned colleagues, they will be able to answer that, but from Mr. de Kok's side, Monday we'll be ready.
All right.
I should also thank you.
All right. I'm sure we can take it from there. We'll see how things pan out on Monday. Otherwise, at this stage, the proceedings will be adjourned for continuation on Monday. Oh, yes, Mr. Van.
May I do some small follow-up from the cross-examination? We were preparing for the committee and Gqeberha. We believe we can just add some information that was raised to assist the court.
Or to require an opportunity to re-examine the witness after he has been cross-examined? Depending on what comes out of cross-examination.
Yes, but only for purposes of assisting this inquiry.
Okay, I'll let you ask the questions.
Thank you, Madam. We won't be very long. Mr. Calata, you asked your legal team to enlighten the court in relation to the presence of FW de Klerk at the State Security Council meetings, and we'll do so right now. Malady, we can confirm that FW de Klerk was present at the State Security Council meetings of 19th March 1984, and Malady, we can refer you to the bundle, the Calata bundle. It's item 1, and the minutes are page 1 to 7. And you will see that Mr. F.W. de Klerk's name appears, I believe it's the 7th name on the list on page 1. And in relation to the meeting on the 10th of June 1985, we refer this Honourable Court to item 6 on the bundle, and that's at pages 22 to 26. And when that goes to page 22, you will see that Mr. F.W. de Klerk's name is reflected in the 4th name on the list of those who were present at that meeting. I'm not going to rehash what took place at those meetings, but the witness has already given evidence on those aspects. But since my learned friend for the community, Mr. Gqeberha raised the question of the Zietsman inquest findings and the status of those findings, I can just put one further question to him. Mr. Calata, to the best of your knowledge, the findings made by Judge Zietsman in that second inquest, were they ever taken on review or challenged?
No, Judge, not as far as I know.
So to the best of your knowledge, those findings stand unchallenged as we speak today?
Yes, Judge, they stand unchallenged.
And in relation to the signals, certain questions were put to you. I'm pretty certain that some of my learned friends for the former state officials might suggest that the amnesty proceedings don't reflect any evidence that the killers on the ground ever had sight of that particular signal. In your view, does that matter, whether they had sight or not?
Ma'am,
What do you think? The witness can't decide that. He doesn't know. If my learned friend wants to lead evidence, he can stand there, we can cross-examine him.
Okay.
Can I add, my lady, that we thought that we were going to get some enlightenment, but it's actually proper re-examination, and I don't think that is what the idea was that I got from Mr. Barney's report.
Milady, it's a technical point arising from the amnesty proceedings, and since it's late in the day, we're not seeking to re-examine on that point. We will raise it when we lead our private investigator. Milady, that concludes it from our side. Milady, we have been hoping to, since we still have 45 minutes left, to start with the evidence of Lukhanyo Calata, Paul Calata's wife. I don't know whether that's an opportune time to commence with her evidence.
If possible, I would rather we deal with the evidence of one witness to conviction.
As the court pleases.
Milady, does that mean I can't cross-examine Mr. Varney today?
Milady, there is actually one matter that we can assist the court. The F.W. de Klerk Foundation, there was a statement that was put to Mr. Calata, and we can bring to your attention where you can find that statement, Milady. It's not currently in the record. We don't have a copy of it at this stage, but we will hand it up on Monday as an exhibit. It was published by the F.W. de Klerk Foundation. I'm just seeing if I can get a date of that statement.
I'm sure Monday will still be a good time to get that statement. I don't think there's any agency.
So the media statement is dated 5 July 2021. And milady, there's one sentence which was raised in the evidence, and that can be found on the bottom of the first page of that statement, and I will read it into the record. Because of an informal agreement between the ANC leadership and former operatives of the pre-1994 government, the NPA suspended its prosecutions of apartheid-era crimes. Milady, that is the sentence that I believe the witness was referring to.
You confirm that, Mr. Calata?
It is indeed so, Judge, yes.
Okay. Can you remind me what the date will be on Monday? The 9th, all right. Okay, unfortunately, Mr. Calata, you still have to present yourself on Monday for further examination. And with that, the proceedings will be adjourned until Monday, the 9th of June at 9:30. But I will make provision for parties traveling from outside Gqeberha. We can start at 10 o'clock. I will still be fine with that. Already with that, the court will adjourn for the day.
Thank you.